Good morning. Good morning. It's an unusual Friday to stream, but it's because today we are covering whether or not the TikTok ban is going to get a reprieve or is TikTok out of operation. So today we will be going to oral arguments at the Supreme Court. Though federal courts do not give us any audio feed or any video feed, the Supreme Court does audio feed of the oral arguments. There are two cases technically on docket today. They've been consolidated. We're going to talk about what that means. We're going to talk about really the heart of this issue. If you've not watched Supreme Court arguments before, we will talk about the different standards you're going to hear about. So I'm going to roll the intro. We'll talk about what they're trying to decide today. But could TikTok cease operations in the United States as of January 19th? Yes, that is a real possibility. But the arguments here about whether there are free speech rights or not free speech rights is incredibly interesting, I think. I hope you think so too. And if you've never listened to this kind of peppering questions from the Supreme Court, it might be a different type of law for you today, because the way the Supreme Court questions is different than most courts, and you will hear all of it. So let's talk about TikTok. Let's talk about whether or not TikTok's getting banned. And for those of you that have been through law school, paralegals, work closely in the law, today is going to feel like law school, and we're going to talk about that too. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
So there are a few things we need to talk about today, because what the arguments, let me just back up. Let's do a quick road so far, and then we'll talk about what the standard is. And then we will get into a little bit of like law nerd law school, and then we will go to the Supreme Court. So do not worry. Here's what happened. Congress of the United States passed an act that is and I'm reading this directly because otherwise I'm not going to get it right, the Protecting Americans from Foreign Adversary Controlled Applications Act, or the because it's the PAFFACAA. So that is what I am calling this bill. Emily, is that really what we're calling it? Yes. That's really what that's what we're going with today. That's what we're going with today. So that was passed by Congress. TikTok and a group of creators sued and said, Congress, remember that whole like, you shall pass no law, like First Amendment free speech. This is a speech platform. You can't ban it. What are you doing? Congress said, cute, but this is a foreign controlled app, and therefore that's not what I wanted to do. They do not have a free speech right. So too bad. This wandered through the courts. The courts agreed with Congress and said, yes, this law is constitutional. What is the Supreme Court trying to decide? They are evaluating whether or not the law or the act passed by Congress is constitutional. To do that, the Supreme Court uses different levels of scrutiny. For all of you that are like, oh God, are we talking about levels of scrutiny? Yes, welcome to 1L. Levels of scrutiny. So the Supreme Court uses different levels of scrutiny depending on what the law is to determine if a law is constitutional. Strict scrutiny is, guess it, chat. Strict scrutiny is the strictest scrutiny, right? So strict scrutiny is the strictest level of scrutiny the Supreme Court applies. Yes, it can apply to First Amendment cases, but it generally applies to cases dealing with some type of fundamental right, First Amendment, or suspect classification, if you're classifying people by race, religion, national origin, etc. So here, TikTok is arguing fundamental right. It doesn't get much more fundamental than free speech. They put it first for a reason. That is the argument from TikTok. Congress is saying not Congress, Garland, because the Justice Department, but essentially the government is saying, this is not a free speech issue. This is a security issue. B, even if it is a free speech issue, a foreign entity does not have a free speech right in the United States. And C, even if they did, and you do apply strict scrutiny, the law meets the strict scrutiny test. And see, remember we said strict scrutiny doesn't apply. The other levels of scrutiny are less onerous, so easier to find something is constitutional. Those are intermediate scrutiny and rational basis test. If we need to get to the rational basis test later, we will. All of you are going to be ready to take a 1L constitutional law exam by the end of today. Strict scrutiny starts with, hey, this law is probably unconstitutional, and we work backwards from there. So we go from this is unconstitutional, and then we work back into, is it constitutional though? With the other test, it starts with this is constitutional. You got a long way to go to prove me that it's not. So the level of scrutiny that applies here is critical to whether or not this law will be upheld. And scrutiny based on a fundamental right goes into strict scrutiny. So if we are not in the fundamental right realm, which is why you're going to hear them talking about First Amendment a lot today. If we're not in the fundamental right realm, then does it go to the lower level of scrutiny, which means the law is more likely going to be found constitutional. The level of scrutiny matters the most here, and they are going to be doing the most to argue it. What does strict scrutiny mean? Look, this is an entire year of law school, but generally, compelling government interest. Is there a compelling government interest here? The law must be narrowly tailored to achieve this interest. Is banning the entire app narrowly tailored or not? And it must be the least restrictive means necessary. So the things you're going to hear, the buzzwords for your law school exam are compelling government interest, narrowly tailored, least restrictive means. Those are our three things for strict scrutiny. Is this a fundamental right? Is this not? Angie said the level of triggering recalling con law 1 right now. I know. You come here to talk about the law and the celebrities and the pop culture. And then we get to strict scrutiny and rational basis. And everybody's like, I put those books away. Crispy Cookie, this is self-study. But self-study for your continuing ed here. Go with self-study. I need to start applying to get us continuing ed numbers. I will absolutely do that. So for everybody who's pulling out their con law outlines, this is what we're doing. So these are the buzzwords you're going to hear a lot today. We're going to hear a lot about whether or not this is a fundamental right, whether or not TikTok has a fundamental right. And that, remember, there are 2 consolidated cases. The court set aside 2 hours. It could go longer than that today. The 2 cases are TikTok, the company, and the creators. So we're going to hear from lawyers for TikTok, the company, and for the group of creators, and then for the government. So that's what we're going to get into today with all of the Supreme Court arguments. Will there be a stay or an injunction? We'll see. What does it look like if TikTok gets banned? If this law goes through, or if the Supreme Court does nothing before January 19th, then there are punishments for the Apple App Store, the Google Play Store, any other app store that hosts the TikTok app. So if you have not downloaded it, you will not be able to download it on the 19th. And there are also punishments for anyone hosting it. So if TikTok is hosted on servers within the United States, you cannot host them on servers. I would think that a company, I don't know where TikTok's hosted, but if it's hosted on something like an Amazon Web Service, even if that server is outside of the US, Amazon is a US-based company, I could see that being a problem too. This means that TikTok is going to be a mess soon because there's not going to be server support. You're not going to be able to download it. And most importantly, there will not be security patches for it if this goes through and you can't update it through the App Store. So if you love TikTok, I will say, find your favorite TikTok creators and follow them on other platforms. Because if it gets banned, TikTok will become a buggy, security-ridden mess the way that apps do, any app does, quickly. Find your favorites and follow them on whatever other platforms they have. Substack, Instagram, YouTube. Take a couple days and just be like, does this person have a YouTube? So that is what we are going to do. Grateful Edge asked, what if you're on a VPN and set your country to another country? You would have to have your app store set for another country. Nancy said, is that being argued for the US only? Yes, this is US only. This is a US law. This is the law Congress passed constitutional? Is it not, or is it? So, Darth is saying, should we delete TikTok? I wouldn't yet. It's up to you. And we're going to have to see how it shakes out. So I would wait and see how it shakes out. If security issues become apparent, Wired and all the other tech reporting will let us know. Security issues will be an issue if this goes through. However, we've also seen, Inauguration Day is on the 20th. And without talking anything about the incoming president, that can change things too. So it could get banned on the 19th and shit could still change on the 20th. Spice, she writes, said, does SCOTUS decide today? No. They will not publish an opinion today. All right. Gothwitch said, I'm Colombian. Does this affect me? It depends on what the US does and if it makes TikTok unstable for the rest of the world. I don't know if it will or will not, but it's not going to be banned for you. This is specifically to the US. All right. Chris Bowman asking the real questions. If the Supreme Court can stream audio, why not the federal courts? Because they don't want to. Because they don't know. Because they don't want to. Because they don't want to. That's why. Nikki said security issues are across the internet entirely. Yes, but in other countries, they can still patch it and update the app in the App Store. The US will not be able to update TikTok in the App Store because it won't be hosted in any App Store. So if you are in another country, you will have access to whatever App Store is used and you can still update the app. In the US, you will not be able to get the security updates because the App Stores will not host them. So that is the difference. That's the difference between if you live elsewhere and can still update it versus living in the US and not being able to update it. All right. Are you guys ready to get to the court's arguments? I am. You are. I have to say a huge, huge thank you to all of the help from Team Baker. We got the court arguments because they run through the Supreme Court website, set up on our own streaming YouTube channel so that we could add closed captioning to it. So we've got this all up and running. And so when the arguments end, we don't get yeeted. Jessica asked, would Apple and the App Store get in trouble for TikTok? If they still host TikTok on the 19th, they will be fined substantially. Why is it being banned though? Because Congress thinks it's a security issue. We're going to hear those arguments today. Congress said no. So we will see. Shaz Loves Coffee says we're banned from having TikTok on our work phones due to security issues. Most companies do that. TikTok does have quite a lot of security issues. So yes, a lot of companies do that. All of the governments do that. So let us see. Eric said, what about creator payouts? I believe after the 19th, creator payouts would cease, but TikTok has not said. So we will see. All right. Shall we get to getting with the Supreme Court arguments? These are audio only. I'm leaving this in a large screen so it's easier to read the closed caption. Like that's the only reason we're leaving it in a big screen because it's audio only. So we're just going to watch this screen and audio only. All right. Shall we go to court? Yes, we shall. Let us go. I should also swoop. I feel like a swoop is appropriate as we get into court. Let me know where you're coming in from also and what you're drinking because I've got coffee. I've got a little bit of breakfast. I've got the snow outside. Like it is Snowmageddon, Nashville style, which means we have like inches. My grass is covered and I'm like, oh, snow. So if you keep seeing me staring out my window, I love a snow day for like 3 days and then I'm over it. So I'm very excited, but we've got a tankard of coffee this morning. Let's start court and listen to the Supreme Court arguments. How long will we be here? 2 hours or more? Yep.
Seated. We will hear argument this morning in case 24-656, TikTok versus Garland, and the consolidated case. Mr. Francisco.
The consolidated case.
Mr. Chief Justice, and may it please the court.
This is Mr. Francisco.
Under the Act,
for TikTok.
One of America's most popular speech platforms will shut down in 9 days. That shouldn't happen for 3 reasons. First, TikTok Incorporated is a U.S. company speaking in the United States. The Act requires it to go dark unless ByteDance executes a qualified divestiture. Whether you call that a ban or a divestiture.
Divestiture meaning it has to sell. And TikTok has said they don't want to sell. So the divestiture is you have to sell or you're banned. They're not selling between now and the 19th. That's just not even practical.
One thing is clear. It's a burden on TikTok's speech. So the First Amendment applies. Second, the act is content-based from beginning to end. It applies only to social media platforms that have user-generated content, except for business, product, and travel reviews. Within that content-based universe, it singles out a single speaker for uniquely harsh treatment. And it does so because the government fears that China could, in the future, indirectly pressure TikTok to disseminate foreign misinformation and propaganda. Finally, the act can't satisfy any standard of scrutiny.
Oh.
The government has no valid
No
interest
rational basis
in
at all?
preventing foreign propaganda.
Okay.
And its fallback, that it seeks merely to prevent covertness, makes no sense, since that could be addressed with a risk disclosure. The government's real target, rather, is the speech itself. It's fear that Americans, even if fully informed, could be persuaded by Chinese misinformation. That, however, is a
that
decision
targeting
that the
speech?
First Amendment leaves to the people. Given that, the government's data security rationale cannot independently sustain the act. It is also grossly under-inclusive and ignores the most obvious, less restrictive alternative, simply banning TikTok Incorporated from sharing any sensitive user data with anyone. In short, this act should not stand. At a minimum, you should preliminarily enjoin it, which will allow you to carefully consider this momentous issue and, for the reasons explained by the President-elect, potentially moot the case. I welcome your questions.
A great
exactly
summary.
What is TikTok's speech here?
TikTok, Your Honor, uses an algorithm that in its
This is a very interesting question to me because the question is, what is TikTok's speech? How is TikTok speaking? Remember, time after time, social media apps end up before the court, YouTube, Twitter, X, whatever, end up before the court and say, we don't speak. We don't have any speech. We don't have editorial control. We are not saying anything. We are simply hosting user-generated content. Our algorithm is not speech. We cannot be seen as editorial. We have the benefit of Section 230 because we do not editorialize. So we're not a publisher like a media outlet like the New York Times. We are a host more like an internet service provider. So social media regularly says we are not speaking. We are just hosting, because if they are the ones doing the speaking, Section 230 doesn't apply. And then if somebody says something on TikTok, you can sue TikTok for it and be like, you said this. So TikTok going the what is our speech is very interesting to me because social media fights against this so much.
view reflects the best mix of content. What the act does is it
their
says
algorithm
TikTok
is
cannot
speech.
do that unless ByteDance executes a qualified divestiture. That's a direct burden on TikTok's
Google's
speech,
lawyers are
much
screaming.
less of a burden than the one that this court struck down in the Simon & Schuster case, where all the author had to do was take a certain amount of proceeds and put it into an escrow account for a short period of time to satisfy a civil judgment.
So why does a restriction on ByteDance, which is not a citizen, is not located in the U.S., a restriction on TikTok?
Because what the law says to TikTok is that TikTok, you cannot use the algorithm that you prefer to use unless ByteDance executes a qualified divestiture. So the law therefore falls directly on TikTok itself. It imposes a burden on TikTok speech, again, a much more significant burden than the one that was struck down in Simon & Schuster.
So you're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok's speech. So why can't we simply look at it as a restriction on ByteDance?
Interesting question.
Because I think the burden falls directly on TikTok, and I can use a hypothetical that helps illustrate the point.
We
Suppose
would love a
that
hypothetical.
China used its leverage over Jeff Bezos' international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to either sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos' First Amendment rights.
But he's a
that would
US
also violate the Washington Post's First Amendment rights, because they are ultimately the one that's suffering the burden under that law, because they have to go dark and close up their books.
Counsel, you began by saying this is a U.S. company operating in the United States.
Yes, Your Honor.
But the ultimate company that controls
MSNBC has a particular
was found
Apologies.
by Congress, and I'll quote this, to be subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work, quote, and to ensure that the Chinese government has the power to access and control private data that the company holds. So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor, I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and...
Well, just hold a second. Well, as I said, you began by saying this is a U.S. company operating in the United States, and it seems to me that you're ignoring a major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And
For those of you asking, who is ByteDance? ByteDance is the company that owns TikTok. So ByteDance is the owner of TikTok. So that is the company underlying TikTok. So they are talking about, okay, not talking about TikTok. Let's just talk about ByteDance, the company.
I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States with its own set of free speech rights.
Do you dispute the fact that ByteDance has ultimate control of TikTok in its corporate organization?
Yes, Your Honor, I do dispute that, but I also don't think that it matters, because even if China could exercise overwhelming power against TikTok versus ByteDance, I don't think it would change the analysis. And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the Bezos children hostage.
What?
And it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down, because that would violate Bezos's rights and the Washington Post rights.
I think the hostage situation takes over the you have to sell the Washington Post. This hypo is way outside of hey, TikTok is owned by a foreign company. This is like, but what if Jeff Bezos's kids were kidnapped? What? This has gone off the rails immediately. Look, creating hypos on the spot isn't great, but they had time. I mean, limited time to prepare for Supreme Court oral arguments, but they did have time.
Maybe what they could do is come in and say, you need to disclose the fact that you're under this amount of coercion.
I feel like everyone would know.
People who are looking at the paper understand it and can make their own assessment. But I think the First Amendment rights of both Bezos and the Post would be directly implicated, notwithstanding that China in that scenario has effectively total control over what gets printed in the Washington Post.
Counsel, let me break this down. I understand your argument that there is a First Amendment right that the U.S. company has. I'll go that far with you, okay?
I'll take it.
Because we're affecting their ability to talk in whatever way they choose. The Washington Post could choose without any influence or threat against the children of Mr. Bezos to promote Chinese policy, and our First Amendment would permit them to do that if they chose it independently, correct?
Yes.
Now the question becomes, so it's not, that's just a given that they have a First Amendment right. The next question is, assuming they do, what's the level of scrutiny we apply? Right. Isn't that what the issue here?
That is certainly one of the issues, Your Honor.
It is the issue,
So if we get
Your
to
Honor.
that side of the issue, that TikTok USA has some sort of First Amendment right, taking your example, if the government said no speaker is free to speak under a criminal compulsion by someone else because of extortion, because of kidnapping. We are doing this because it is the only way to ensure the safety of people, that they are not going to be kidnapped or threatened, their lives threatened. You don't think that the government has a compelling state interest in saying, if there is a threat, a physical criminal threat against someone to do some activity, that the government couldn't say, I'm not questioning whatever the content is of that activity. I'm simply saying we, in our governmental powers, have a right to say, you can't do that. You can't speak.
And that's going
Sure,
to
Your
the
Honor.
strict
So,
scrutiny.
to take your question in pieces, I do think that they would have a compelling interest in that scenario to do something. But what I don't think is that they could simply target speakers in speech. Take, for example, generally applicable laws like the
So
trading.
you think in that situation that the only thing the government could do is tell the Washington Post, disclose to the public that you are saying this because you are being forced to?
He's saying
So
he thinks
sure.
that's the least restrictive
That's the
means.
only remedy the government could undertake?
No, Your Honor, but I want to make sure I understand the hypothetical. The compelling interest
Which hypothetical?
is in,
We're lost on
preventing
yours.
this kind of compulsion, coercion, and ultimately harm to children. And I think that the government has a lot of different ways
I mean, they're
they
not
can
arguing
address
harm to
that through
children.
speech-neutral laws. And I was going to point to things like the Trading with the Enemy Act or Russia sanctions. You can broadly say and attack
They haven't
problems.
been very effective.
Well, be that
We're
as
still having people kidnapped, we're still having coercion.
And be that as it may, you can say
She's like, right,
to
that doesn't work.
Americans, you cannot collaborate with our enemies at all, and if you do that,
There
you're
are
going to be
laws.
severely punished for doing
All
that.
right, we
But
can
what I
go
don't-
on to the effectiveness of the remedy, but the point is, I
Right.
believe, that even if your First Amendment rights are impinged and there is some protection, the question is at what level of scrutiny?
Yes, Your
Right.
Honor.
And whether that the action is content neutral or
Sotomayor's like,
not.
can we get back to what standard applies?
I agree that that is the way that the analysis proceeds. Here, we believe that the level of scrutiny should be strict scrutiny.
What
but-
is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the D.C. Circuit,
that Alito?
emphasized that there is a
Alito.
long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you.
Do all the judges
I would
just jump
think
in? Yes.
No matter the level of scrutiny,
They do.
that history has to be
But let Sotomayor
important, and I
finish.
wanna
Can we get to what
get
he
your
thinks the
response
standard
to
is?
it.
It could be
I
Kavanaugh.
don't actually think it's important
Could
in
be
this
Alito.
context because that history all arises in the context of bandwidth scarcity. And in that context, you have the government that's in the position of doling out a limited number of licenses. And when you have to dole out a limited number of licenses, you by definition have to pick winners and losers. And when you have to do that, you get a certain amount of discretion. I think that's the whole basis of those cases. You can't really take those cases and
keep going.
you can't really take those cases and extend them to an area where there is no scarcity, like the World Wide Web, because once you do that, there's really no limiting principle. There's no reason why it wouldn't also apply to really popular books or magazines or newspapers or chains of newspapers. The bandwidth scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
Mr. Francisco, let me see if I can break this down. Suppose that TikTok were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not?
Because there you would have to confront a very different question, whether a foreign government
That's an
that was
interesting
speaking
question.
in the United States has First Amendment rights, and I don't know that the court has ever addressed that. But here we've got a U.S.
No, I
government.
understand that. I just want to see where you draw the line. So it's true, the court has never held that a foreign government has free speech rights. And if we were to hold that, I would think it would be because speech by a foreign government, particularly one with enormous resources, is not allowing that does not serve the underlying interests of the First Amendment, which are, among other things, fostering democratic self-government and furthering the search for truth. So let's assume that we start with that, all right? What if TikTok were then not owned by the foreign government, but it was undisputed that TikTok was totally controlled by the foreign government, could not do one thing without the approval of the foreign government? That's different?
I do think that it is different, Your Honor. For example, I've given the hypothetical that I've given.
Which was
but there
terrible.
are a lot of companies in this country that have foreign owners, not just companies like Politico, which is German-owned, or Al Jazeera, which is partly owned by the government of Qatar.
Well, I understand that, but what would be the reason for drawing that line?
Sure,
if there's a good reason for saying that a foreign government, particularly an adversary, does not have free speech rights in the United States, why would it all change if it was simply hidden under some kind of contrived corporate structure?
Because it is a U.S. speaker. I'll give you another example. AMC movie theaters used to be owned by a Chinese company. Under this theory, Congress could order AMC movie theaters to censor any movies that Congress doesn't like or promote any movies that Congress wanted. And I think the reason is that here, where it's conceded, you actually have a bona fide U.S. company. It is not simply a Chinese cutout that is the Chinese government speaking itself.
All right, let's say that's not a
United States company.
Let's say this is not a complete answer to your First Amendment argument, but would you be willing to concede that this is a very important factor that should be taken into account in deciding whether there's a First Amendment violation?
Well, Your Honor, I think that it does help supply a compelling governmental interest, but I still think you have to march through the strict scrutiny analysis and analyze their
compelling
interests.
government interest
I do
goes
not
through
think
strict
that they have a
scrutiny,
compelling governmental interest in the manipulation of content. I think that is in the teeth of the First Amendment, and if you look at the government's brief and the rest of the record in this case, that's really what it's focused on. Their complaint is the fear that the content could be critical of the United States government or could undermine our democracy.
That's the actual
Yes,
fear.
Mr. Francisco, I just wanted to follow up on that line of questioning.
I mean,
Just
free
some
speech is
fact
there so
questions,
you can be
because
critical
It seems
of
to me
the
there are a
government.
couple of things
forgot my notebook.
that the
Hold on.
parties still dispute about facts
notes.
in this court, which is a little unusual. The government says that TikTok, U.S., has no authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
somebody has to be right and somebody has to be wrong about that. What's the fact?
What say you about the algorithm?
Well, Your Honor, we are here on a record, and there is nothing in the record that says that TikTok, like any other subsidiary, doesn't have its own independent making authority. If you look at their record sites, what they point to is the ordinary types of control that a parent company has over a subsidiary company, but it doesn't change the fact.
All right, what is the fact? Are you prepared to make a representation?
Yes, Your Honor. The fact is that TikTok Incorporated as a U.S. company does have a choice over the algorithm. Now, it would be an incredibly bad business decision for them to abandon this algorithm, and they very doubtful would ever do it, but they have that authority. What they clearly have the authority to do is shut down the platform in the face of Chinese pressure. That's actually what they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated as a U.S. company does have its own set of First Amendment rights.
Okay. And then another fact question. Before the D.C. Circuit, you argued that the Chinese government has made clear in public statements that it would not permit a forced divestment of the recommendation engine. Does that mean that some key component of the recommendation engine is under Chinese control?
No, Your Honor. What it means, and this might warrant a little more explanation, what it means is that there are lots of parts of the source code that are embodied in intellectual property that are owned by the Chinese government, and they would restrict, like the United States restricts the sale of those types of things to foreign governments. It doesn't alter the fact that this is being operated in the United States by TikTok Incorporated.
Okay.
So
I got it.
Okay.
I got it. And then you represent that the divestiture is not feasible within the Act's time frame. I'm sorry for these fact questions.
Sure.
I just want to understand what's before us.
We just want the facts.
Would it be feasible in any time frame? I take the government doesn't dispute that it's infeasible in the 270 days provided by law. But would it be
Your Honor,
Right, it's
I
not
think
feasible.
at least as we understand how they've interpreted the
time.
qualified divestiture provision, it would be exceedingly difficult under any time frame for two principal reasons. The first is
Did you
that there's
catch
a
that?
global
It wasn't the Supreme Court said the government has conceded that this divestiture is not super practical in the 270 days that they gave. Like it's not an easy time frame for a large company to sell off its operations in one particular market. And what he said is, no, it's not that we need more time to sell it. It's that we're never going to sell it. Did you catch that? It is never going to be practical. So if it comes down to we need more time to sell it, that's not what they're saying. They're saying it will never work to sell it and it will never be sold. That's not happening. So even though they asked for more time to sort this out, they're not really asking for more time to sell, which was the direction they had taken earlier on is, oh, we just need more time to sell. The direction has shifted to no amount of time will make this practical. We're not selling it. So Aloe Vera said they shouldn't be forced to sell. They're not forced to sell. They have the option not to sell. But if they don't sell, then the law says they can't operate in the US. So that's where we're at. They have a choice. They just don't like the options of the choice. And some choices are like that, where both options are shit. But it's interesting that they said, no, it doesn't matter how much time we have. This is not happening. It's interesting to hear it. Never, ever.
team of engineers.
So I'm gonna back that up real quick because that had been a core part of the argument. We need more time. This is not a we need more time argument.
Divestiture provision, it would be exceedingly difficult under any time frame for two principal reasons.
Under any time frame.
The first is that there's a global team of engineers that are some in China, some in Europe, some in the United States that maintain and update the original source code. And as we understand their interpretation, a qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason is because, as we understand how they're interpreting it, a qualified divestiture would divorce the U.S. platform from the global content.
Yes.
So, for example, there are videos created in the United States. There are videos created in Ireland. In order to get global content, we need access to the Irish videos. They need access to the U.S. videos. We understand that couldn't happen.
Okay, so you think it's probably not feasible in any timeline?
Well, Your Honor, I think it'd be extraordinarily difficult.
Okay, last fact question, then I'll yield the floor here. The government admits that it has no evidence that TikTok has engaged in covert content manipulation in this country, but says that ByteDance has responded to PRC demands to censor content outside of China in other countries. Again, you deny that in your reply brief. Somebody has to be right about that.
Well, Your Honor.
So they're saying, look, there's no evidence of manipulation, but they say, TikTok denies, but they say, but we have evidence that the CCP is actively censoring content outside of their own country, which is interesting. Do social media companies within the US not censor content? No. Is that the conversation for today? No. Does that happen? Yes. But that's not what we're talking about today. Is content censored outside of the country? And the US has said yes. TikTok has said no.
Demands to censor content outside of China in other countries. Again, you deny that in your reply brief. Somebody has to be right about that.
Well, Your Honor, the problem there is everything that follows what you just read is redacted, and so I don't know what it says. What the record shows is two things.
Wait, it's even redacted for them?
First, what you just said. They haven't done anything here in the United States with respect to TikTok Incorporated. And second, the record also shows through our transparency reports that we haven't removed or restricted content on the TikTok platform in other parts of the world. And TikTok doesn't operate in China, it operates in other parts of the world. We haven't removed or restricted content at the request of China. That's what we put out in our regular transparency
Removed or
reports.
restricted though, doesn't necessarily cover covert content manipulation, though, right?
Well, Your Honor, I'm limiting my response to what's in the record.
Okay.
It's very difficult for me to respond to things that where I don't know what the accusation
I have
is.
other questions about the secret evidence in this case, but we'll get to that
The
later. Thank
secret
you.
Mr.
evidence in this
Francisco, can I
case.
ask you a question about the relevant speech here? So it strikes me
That's
that this is
gonna
a little
be,
different than your Bezos example, because there it's clearly
Barrett.
content discrimination because we're talking about the ability to post particular articles versus other articles. Am I right that the algorithm is the speech here?
Yes, Your Honor. Well, I would say it's, the algorithm is a lot of things. The algorithm has built within it, it's basically how we predict what our customers want to see.
Every lawyer for every other social media app that is coming ahead of this court has argued 100% that the algorithm is not speech. Every lawyer that works with Google, TikTok, whoever, well, not TikTok, they're there, Twitter, whatever, is screaming at their screen right now because they spend all of their time arguing. However, if anyone wants to go ahead and sue TikTok and say TikTok isn't afforded 230 protection, the door just got flung the fuck open because they're like, yes, the algorithm is, this argument is going to change or has the potential to change so much with what's going on with Section 230. Oh, fascinating. I'm fascinated. I'm going to back up. It's a great question by Judge Barrett. Emily, is it easier for you to tell the female judges apart? Yes, it is. Also, this is not the Supreme Court I studied when I was in law school. It's completely different, so it's harder. But this is wild. This is wild.
Your Bezos example, because there it's clearly content discrimination because we're talking about the ability to post particular articles versus other articles. Am I right that the algorithm is the speech here?
Yes, Your Honor. Well, I would say it's, the algorithm is a lot of things. The algorithm has built within it, it's basically how we predict what our customers want to see.
The editorial discretion.
Yeah, the editorial discretion. It also has built within it the moderation elements, all of this kind.
All of the social media platforms have been arguing that the algorithm is not an editorial decision. This goes directly to Section 230. Oh, bitch. Oh, boy. That's wild. So, yes, for all of you that are like, don't they all use Tracy in the chat said, don't they all use an algorithm? Yes, but the other social media companies argue that the algorithm is not a form of speech, that the algorithm is not editorial decision, that the algorithm algorithms. It's just like, you want to watch this video? I'll show you another video like it. The algorithm's not speaking. There was the Google case that went to the Supreme Court. Google argued and won on Section 230 protects them from being sued based on what they are showing someone because it's not an editorial decision. The algorithm is separate. This argument undermines all of Section 230, which is why lawyers everywhere are going to scream. And for those of you asking in the chat, thank you for bringing me back. What is Section 230? Section 230 is the protections in the United States that keep the social media platforms from being sued directly. So if someone says something shitty or defamatory, it would have to be defamatory, or threatening about someone else on YouTube, that's the platform we're on. You can't go sue YouTube and say, hey, YouTube, you defamed me because this person said the thing. YouTube's like, we have Section 230 protection. We just host it. Go sue the person who did the thing. And you can't sue YouTube. But if YouTube promoted that video and the algorithm is an editorial decision, then YouTube becomes more like the New York Times being sued for defamation and less like your telephone company being sued because somebody called you and threatened you. So those are the differences. Section 230 was meant to protect you from suing, really back in the day, the telephone company because somebody said something on a listserv, because this all started in like 1996. But the analogy was, if somebody calls you up and threatens you, you can't go sue AT&T because they delivered the phone call. You've got to sue the person that threatened you. That was the same analogy. You can't go sue YouTube because the video's on YouTube. You got to go sue the person who did the shit or said the shit. He's saying, well, the algorithm is speech. And all of the other companies have spent all of their time arguing the algorithm is not speech. Oh, boy.
And it comes together when the source code is translated into executable code in the United States. In the United States, that executable code is then subject to vetting, review, moderation through content moderation algorithms, and that so it ultimately lands on the TikTok platform.
But what we're talking about as a net choice is the editorial discretion that underlies the algorithm. And I just want to be clear, a lot of your examples talk about, including the Bezos one, the right of an American citizen to repeat
I wanted to see this no better.
what a
I'm
foreign
sorry if it
entity
reflects
says,
in my
or say,
glasses.
you know, I'm hitching my wagon to China, I want to say everything China does. Here, the concern is about the covert content manipulation piece of the algorithm. That is something that ByteDance wants to speak, right?
Well, Your Honor, I think that ultimately it's TikTok's choice whether to put it on the platform.
And you don't want that. Is your client disclaiming
we absolutely resist any kind of content manipulation by China at all. But what I do want to focus in on is what their asserted interests here. They do talk about covertness, but it can't possibly be that all they're concerned about is mere covertness. If all you were concerned about was the covertness untethered from the underlying content, that's something that could be easily addressed through a risk disclosure.
But that goes to scrutiny, the level
Yes, Your
of
Honor.
the application. I'm trying to, I mean, let's say that I agree with you the First Amendment is implicated, and I'm trying to figure out what level of scrutiny applies, and I'm trying to figure out what content, if any, discrimination is going on here. You know, there's a disproportionate burden. Let's say that I agree with you about that.
I think we switched.
No one is
Justices.
preventing you. I mean, you're seeking access to a particular source code, engineering, the recommendation feature. It's the technology that you want. You're not trying to repeat, as in the Bezos example, if we take the speech that the government's concerned about to be the covert content manipulation rationale,
Yeah,
you're
I
not
think-
seeking
is it still Barrett?
to
That's what you guys are saying.
utter that speech.
That's correct, Your Honor. What we are seeking to do is use an algorithm that displays the combination
tell
of
if it was Barrett or
content
Kagan.
that we prefer our users to see
I'm not gonna
on
try
the
to guess.
platform.
And the government doesn't care about that. I mean, the government is
so do my
fine with you doing that. You can invent it yourself. It doesn't even care what content that displays, cat videos or whatever.
Yeah, but
We
I
want
think that
cat
the way that
videos.
the analysis has to unfold is first you ask, is this law burdening our speech? I think we agree that the law is burdening our speech. Then you have to look at whether the
asking if you
law
have speech
itself
rights.
is somehow content-based, not just what their motivations are, but whether the law is content-based. And here, the trigger for this law, the one thing that gets it going is if you operate a social media platform that has user-generated content, unless that content takes the form of a product, travel, or business review. Then within that universe of content, it says there's one speaker we're particularly concerned about, and we're going to hammer home on that one speaker. And then just to make the rubble bounce, they come in and tell us
To make
that
the
one
rubble
of the
bounce?
reasons they're targeting that speaker is because they're worried about the future content on that platform, that it could in the future somehow be critical of the United States or undermine democracy, to pull examples from the government's brief. So I think there's no way to get around the fact that this is a content-based speech restriction, and you do have to go directly to what their interests are. Now, their principal interest is...
I think I'm a little bit surprised by one of the answers that you gave to Justice Barrett. I had understood that
there we
TikTok's
go.
essential complaint here is that they wouldn't be able to use the algorithm that ByteDance has invented, and that they want to use the algorithm that ByteDance has invented.
100%, and if I was unclear on that, Your Honor, I apologize. That is
Okay, because
absolutely
I
the
think
core
what
of the
Justice
claim.
Barrett was saying to you is like, what's the problem here? Because ByteDance is a foreign company. Or maybe this isn't
That's
what
Kagan.
Justice Barrett says, it's just what I say. ByteDance is a foreign
Hold on, I'm
company,
gonna
and you started
We're going to back that up real quick. That's funny.
that ByteDance has invented, and that they want to use the algorithm that ByteDance has invented.
100%, and if I was unclear on that, Your Honor, I apologize. That is
Okay, because I
absolutely
think
the core
what
of the
Justice
claim.
Barrett was saying to you is like, what's the problem here? Because ByteDance is a foreign company. Or maybe this isn't what Justice Barrett says, it's just what I say. ByteDance is a foreign company, and you started off with Justice Alito saying, you know, well, we would be making a different argument, and of course that's true. I mean, I would think that Alliance for Open Society makes it pretty clear that you have to be making a different argument with respect to a foreign state or a foreign company. So let's say that they don't have First Amendment rights. The only First Amendment rights lie in TikTok, which does have First Amendment rights. I guess my question is, how are those First Amendment rights really being implicated here? This statute says the foreign company has to divest. Whether or not that's feasible, however long it takes, TikTok still has the ability to use whatever algorithm it wants, doesn't it?
No, Your Honor, and their rights are implicated at a most basic level. In 10 days, TikTok wants to speak. In 10 days, because this law was passed, TikTok cannot speak unless ByteDance executes a qualified divestiture.
Here's why they're talking about the difference. TikTok Inc. is the U.S.-based corporate entity, but that U.S.-based corporate entity that runs TikTok in the U.S. is owned by ByteDance, which is partially owned in China. So it is the two different. So when they're talking about TikTok Inc., they are talking about the US company that owns the platform. And as they're talking about the free speech rights, they're saying, okay, ByteDance doesn't have free speech rights, but TikTok Inc. does. If TikTok Inc.'s speech rights are implicated, then what is the difference? So I'm very interested to see how he's getting back to, okay, but the speech is the algorithm, which again opens a giant wrecking ball sized door into the 230 arguments.
That's not just ByteDance's choice. That is a condition.
Well, I realize that
ByteDance
definitely has effects on TikTok if ByteDance acts in the way that you are assuming it will act. So this is not to say that the First Amendment isn't involved, because TikTok is going to suffer some pretty severe incidental effects. But they are incidental, aren't they? Because the statute only says to this foreign company, divest or else, and leaves TikTok with the ability to do what every other actor in the United States can do, which is go find the best available algorithm.
I very much disagree that the effects are incidental, because the way that this law works is it is only triggered if somebody is engaging in speech based on their content. User-generated content, except for business product and travel reviews. It then singles out a single speaker, and you have the concession for the government that one of the reasons they've singled out that speaker.
A lot of emphasis on the idea of just like, you know, I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure that we've ever said anything like that. You know, let's put aside your argument that this is facially content-based. It seems to me that your stronger argument, or at least the one that most interested me, was this argument of, look, if the government is doing something specifically for the purpose of changing the content that people see, that has to be subject to strict scrutiny. But I don't see that as affecting TikTok, as opposed to as affecting ByteDance.
Well, no, I very much do see it as affecting TikTok, because they choose this algorithm because it reflects the mix of content. The government's fear is that China could come in and pressure TikTok through ByteDance to TikTok to alter that mix of content to make it too pro-Chinese or too anti-American. That is very much directly a content-based charge straight at TikTok. The other point I would like
I hear you that it might very well have that effect. I guess what I'm suggesting is that the law is only targeted at this foreign corporation, which doesn't have First Amendment rights. Whatever effect it has, it has. You know, maybe ByteDance will figure out a way to like put this on open source, and then TikTok will be able to use the algorithm.
So, Your Honor, if I could take that on directly, because
maybe TikTok will put their algorithm on open source. Not going to happen. TikTok's algorithm is different than algorithms on other platforms. Maybe they'll just put it on open source. No, but you can see the way, and I think that is Justice Kagan speaking, but you can see the way that this particular judge is leaning, which is ByteDance has other solutions. ByteDance can find another algorithm. ByteDance can divest, and TikTok US can still operate TikTok US. You just can't have the algorithm owned by ByteDance. That's so not gonna happen. That's so not gonna happen. But she's very much getting it back to, but we are talking about a foreign entity that doesn't have free speech rights. So the law, she is saying, is narrowly tailored and directed at just the foreign entity. TikTok US can go find something else and still operate. You can see the way this justice is leaning, for sure.
I think TikTok has First Amendment rights. To the extent ByteDance is speaking in the United States, it, I believe, has First Amendment rights. If you conclude that neither has First Amendment rights, then surely the creators have First Amendment rights.
Yes.
But if you take a step back, what their position is that none of these entities, this is the universe of entities affected by this law, none of these entities have the authority to assert First Amendment rights, which means that the government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get
It's
no
too
First
pro-cat,
Amendment
not
scrutiny
nearly
by
enough
anybody.
pro-dog.
That cannot possibly be the case, yet that is the effect of their position. The last point I'd like to emphasize, though, is this law, like the Playboy case, like the Hobby Lobby case, has built with...
I think the underlying fear of the government goes well beyond, is it too pro this or too pro that? I think that's all redacted. I have a lot of speculation about that, but that's all redacted.
In it, a less restrictive alternative, which is the general provision, by definition designed to protect against the very harm the government is identifying. Suppose New York State passes an asbestos abatement law. They say these types of buildings have to abate asbestos. In addition, New York Times, you have to abate asbestos in your building, and they say there are two reasons for this. One, we want to abate asbestos. Two, we hate the New York Times editorial page.
I mean, who doesn't
Surely,
at this point?
At the very least, what you're going to say is you can't target the New York Times directly. What you can do is throw them into the general process. We think that's the minimum that should be done here.
Thank you, Counsel. We've been talking about connection between the regulation of TikTok and the burden on expressive conduct. And your basic position is that interfering with the ownership of TikTok constitutes a direct regulation of the expressive conduct of other people. What is your best example in our precedent of a situation where we've a regulation
Robert's
of corporate structure?
Thank you, Peggy. Peggy's got this nailed.
Been
Peggy's
treated
like,
as
here
a
we go.
direct regulation of expressive conduct.
The regulation of a corporate structure, as Your Honor, I don't have a case at my fingertips. I can consult.
Well, I don't have one at my fingertips or any other
rebuttal, but I think it's quite clear, though, that if you're saying to a company, you have to stop talking unless somebody else does something, and that's imposed by the force of law, it directly affects that company's speech.
Well, it's again, I don't know if it's directly affecting the company's speech or the speech of third parties, and I'm not sure what.
And I think the third party speech argument is stronger.
But again, I'm not sure there's another case where we've said that regulating a company others' expression should be treated as direct imposition on their speech in terms of the standard of review, for example, when it's based on derivative regulation of corporate structure of somebody else.
Well, Your Honor, I think that it's, I would concede that this is a pretty unprecedented case. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that
that's why we're all
if
here.
a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech. And they do it for content-based, viewpoint-based reasons, and in particular.
And that's the argument we're going to get to next, right? Because these cases are consolidated. So there are a group of creators also bringing their case before the Supreme Court today. So the argument about speech of creators being infringed is going to come up next versus the speech of the companies coming up. And again, social media companies have fought in court long and hard that they are not speakers. They are hosts of a platform. They don't have editorial control. TikTok just came in and was just like, ha, fuck it. The algorithm is speech, which is what every other company has been arguing against every time these cases come up. So it's interesting to see TikTok just be like, we're save ourselves right now. Damn it. But I'm interested to hear the arguments that will be different when it comes to the creator's speech.
On this record, because the speaker that is ultimately being shut down, they don't like the speech of that particular platform. That's a real problem.
So it may be a real problem or may not, but I just am wondering if there's any precedent where we have that same connection and that it affects the standard of review.
And they're asking,
you would treat it as a direct restriction on expression. Even the only thing the law does is say, in this case, somebody other than the Chinese government has to own.
So we don't have any direct precedent along the lines that you're citing, but we do have precedents. We have cases like Akara. And what Akara says is if the law is totally speech neutral, then that's one thing. We have cases like O'Brien, which say if the law doesn't care about speech but happens to draw in speech, that's another.
And I think there's an argument here, we'll see if we get there, but I think there's an argument here that this is speech neutral. Right? It doesn't matter what's said on TikTok. That's not the issue. The ownership's the issue. So I think there's an argument that this is speech neutral because it doesn't matter because it's anything on TikTok because of the ownership. We'll see what the court thinks of that.
Both of those cases make clear, however, is that when the law is concerned with the content of the speech, when the justification is based on the content of the speech, that's cases like Reed 2, then you do trigger strict scrutiny.
So then I think your argument comes down to, is this direct concern with speech, or is it concerned with the potential for Chinese interference with the level of interference indirectly? In other words, they're not coming back. The Chinese government, TikTok, doesn't care what the people are saying on TikTok. That's not the concern. The concern is that they are regulating a particular channel of communication. And I just wonder if there's any precedent for that type of thing. They're not saying we're going to restrict this content and that content, but not this. They're just saying we're going to be in a position where we can control what happens, whether it's based on expression, whether it's based on anything else.
So, Your Honor, I disagree, and I think if you take a step back and look at this record,
I think
it is quite clear that it is focused on both current and potential future content on TikTok, TikTok Incorporated. Here, you don't have just an act that is based on speakers and speech. It's triggered by speech. It's focused on a single speaker, TikTok Incorporated. TikTok Incorporated.
Justice Thomas, anything further? Justice Alito?
What if Congress, if there were nothing in this act about content moderation or covert manipulation, what if it was just about preventing what Congress viewed as an enormously powerful, popular application from gathering an arsenal of information about American citizens, and they said this is the worst offender and we're going to require divestiture by this offender? Would there be a First Amendment problem there? And if you think there would be, what would the level of scrutiny be?
Yes.
That's the heart of the issue. I'm going to back this up because this question, and especially for those of you that are like, it's really hard to listen without seeing people's faces talk. I get it. This is really the heart of the issue.
Application from preventing.
Hold on, I'm backing up a little
in this
further.
act about content.
TikTok Incorporated. Speaker TikTok Incorporated.
Justice Thomas, anything further? Justice Alito?
What if Congress, if there were nothing in this act about content moderation or covert manipulation, what if it was just about preventing what Congress viewed as an enormously powerful, popular application from gathering an arsenal of information about American citizens, and they said this is the worst offender and we're going to require divestiture by this offender?
That's the question.
Would there be a First Amendment problem there? And if you think there would be, what would the level of scrutiny be?
Yes, there would be a First Amendment problem if you had a law like this that was only focused on speakers, those who use user-generated content other than product, travel, or business.
Well, Congress concludes that this particular entity is the worst. This is the worst offender, and it happens to be an entity that is involved with speech.
If all you had, so I want to make sure I understand the hypothetical. The only provision you have is one that says this company has to shut down because of data security.
Right.
I would have a different set of arguments.
And I see many of you in the chat are like, hey, but other companies also collect. We are in the very narrow view of this problem with this company. We're not talking about what any other social media company does. The Supreme Court is very narrowly focused on this company and what this company does because of who they own. And when you look at the information gathered, it is substantial. Information gathered by other companies, not at issue here today. So it's not going to change things. I know you guys are chatting about it in the chat, but it's not going to change things. The focus is really on this. And so the ownership of this company is the issue. And they're saying, look, if the issue is just the concern over data collection, is there then a First Amendment issue? The Supreme Court is trying to parse level of scrutiny here. So it all goes back to what rights, if any, are being infringed on, because they are trying to determine if the law written by Congress is constitutional or not. So what laws are being infringed upon, or what fundamental rights and constitutional rights does this law infringe upon, if any? So they're trying to get to the core of what is the actual question here and what is the actual problem here. So is the actual problem here that the algorithm has a free speech right, or is really the core of the issue here the data collection? So they're trying to narrow it down to get to really, is this law unconstitutional, and are there constitutional rights at play here?
I think it would still implicate the First Amendment, particularly where you have strong evidence that they were being targeted in part, at least because of their speakers and speech. Suppose Congress passed the law that you
all right, you're changing the hypothetical by injecting congressional concern about that.
Okay, well, I'll put that to the side.
So what would your argument be? It would be an equal protection argument?
No, I'd still be saying that ACARA itself makes clear that where a law disproportionately burdens just a speaker, we have to subject that to scrutiny to suss it out, to suss out whether the asserted interest is the actual interest. There, the asserted interest is in data security. I think I would have a couple of arguments under whatever form of scrutiny you wanted to apply, whether it is strict scrutiny or intermediate scrutiny in that context. I would say first that law is dramatically under-inclusive because it categorically exempts e-commerce apps that this record shows have comparable ties to China.
You say, I don't want to prolong this too much. You say this is not like ACARA.
Branched it out
primarily
now into
because
e-commerce
you say
apps.
that the divestiture requires the new company to cease using the algorithm, right?
No, I think it's not like ACARA for a much more fundamental sense. ACARA involved a totally speech-neutral law.
ACARA
it
being
didn't
a
go
different
after
case.
speakers at all. If you had a law in ACARA that said we're going to prohibit prostitution in bookstores only, then I think that ACARA would have come out differently. There would have at least been...
Sir? What? Leave the bookstores alone, sir. You do not know what is in my books. Leave us be. But also, his analogies have been wild.
You know, some kind of intermediate scrutiny, potentially strict.
All right, well,
that's the law that I think is your hypothetical.
Walk away from the hypothetical that I posed.
He did. He walked immediately away from the hypothetical. You know what that lawyer didn't want to do is answer that hypothetical. It's called bridging. He took the hypothetical and bridged it to somewhere else. And Justice, it sounds like Alito keeps saying, you're not answering the question. He is wiggling around the direct question for a reason.
Narrowing in on what your on what your argument is.
He doesn't want to be narrowed in.
I understood you to say that that would not be a solution to the problem, because one of Congress's motivations was based on the content of TikTok. Am I wrong in that? Did I read your argument incorrectly?
Well, I think
You
that,
continue to read that correctly.
I want to make sure I understand what you're saying. I certainly think that because one of the motivations was content, that is an enormously important fact. I was trying to answer your hypothetical where we were trying to take that out of the mix. And the reason why ACARA is different is because ACARA didn't just simply say no prostitution in bookstores. That's what your hypothetical effectively says.
They're talking about a different case.
It says no data security problems
I agree.
in
Book talk's one of the best
speakers or
things
in
to come
this
out of
particular
TikTok.
speaker. And I think that that would trigger, at the very least, intermediate scrutiny.
All right, thank you.
He's like, just stop.
That goes to my question, which is, Justice, the Chief Justice asked you whether or not we've ever had a case where pure ownership was at issue and not speech. And I don't think we've had one like that, you're right. But I don't think that your that the question gets to the essence of your argument, is it? The essence of your argument is you're being asked to divest because of speech, correct?
What I appreciate about Sotomayor in these arguments, particularly today, is Sotomayor keeps getting back to the question. She's like, you can get on about kidnapping and bookstores all you want, but isn't the heart, like, aren't we trying to answer this question? Can we get back to the question? And this is what lawyers do, right? We've got to define the question first before we answer the question. She's like, can we get back to answering the motherfucking question? Isn't the question that we are trying to answer is there a First Amendment right being infringed upon, and who has the right? I appreciate it so much.
If I get past that, if I go to Justice Alito's point, which is, I don't think it's just about speech, it's about data control. If it's about data control, and assume, for the sake of argument, that I believe intermediate scrutiny applies to the data control provision, then your arguments would be different, wouldn't they? They would be under inclusiveness, they would be other arguments, correct?
Well, Your Honor, I think they'd be very similar, because I think the nature of our arguments work just as well under intermediate and strict scrutiny. If I could unpack that a little.
No, I'm not going to, because we're going to run out of time. We're going to need to figure out what intermediate scrutiny means. But I'm not sure it means what you do, which is, I don't think any of our cases have ever suggested that we have to use the least restricted means under intermediate scrutiny.
No, because you don't. Because you don't, sir. No, because you don't. Least restrictive means does not go under intermediate scrutiny. That I remember from law school. Don't try to change what intermediate scrutiny means on me. I got rid of my 1L books because I was trying to not be a book hoarder, and I regret it wildly at this point. I'm like, I'm never going to use my 1L books again. I like making YouTube videos. Wrong. The way I wish I still had my 1L con law book right now, because damn. But no. When we're talking about intermediate scrutiny, and again, the Supreme Court is trying to decide, is the law passed by Congress constitutional or unconstitutional? And there are different tests to decide that. Strict scrutiny assumes that the law is unconstitutional and works from there. Intermediate scrutiny doesn't. So if intermediate scrutiny applies, all you need to find is if there is an important, not compelling, important. Do important and compelling mean different things? Yes. Is there a compelling government interest? Is strict scrutiny. Is there an important government interest? Lower standard, that's intermediate scrutiny. Scrutiny. Is that important? And then is the means in the law substantially related to the interest? That's it. No narrowly tailored, no least restrictive means, no. Just substantially related. Substantially related is a much lower burden for this law to lift than narrowly tailored and least restrictive means. Is banning an entire app the least restrictive means necessary? I don't know. Maybe not. But is it related to the interest? Probably is. So under intermediate scrutiny, we go a lot further to this law is probably going to get upheld than under strict scrutiny, which presumes maybe not and goes back. All right, let's continue. Laura in the chat asked, will we find out the decision today? No. If the court does anything, they could, in more quick order, put an injunction to say on the 19th, this ban shouldn't go into place until we rule, but I don't think they're going to do that. Are we going to see them rule today? No. Are we going to get a vibe for which way they're going? Maybe. Is it likely that this will go into effect on the 19th? Yes, that's the most likely outcome at this point. All right, let's continue.
Have said we have to use a reasonable means.
And if I could
Sorry,
respond
I had to
to
yell
that
about
point specifically, I
intermediate
completely
scrutiny.
agree it's not a least restrictive means alternative.
Yeah,
Your
good.
Honor.
We all agree.
But you do have to at least consider alternatives. Here, if the concern, let's take the data security concern, which you put your finger on.
I know you want to keep going on, but I can't let you because I can't monopolize the argument, okay? But
Please
let me
do.
just
Your
get
questions
to
are
the
good.
bottom of that, all right? You seem to suggest
I
that
can't let
Congress
you
has to
keep going.
actually look at all of the alternatives and say no. I don't think we have a case that says that.
I am
If
not
from the record it's clear that alternatives won't be adequate for whatever set of reasons, isn't that enough?
If the record were clear on that, that might be
Okay.
enough.
Now
But
I take
here
that.
on the
Now let me
key-
go to the next question and the last.
If I could, Your Honor,
No,
just one sentence.
no.
If on the key, less restrictive alternatives, they had actually considered them and said what you suggested, this would be a different case. But our point is that on the key, most obvious, less restrictive alternatives, a law, for example, that simply prohibits TikTok Incorporated from sharing any sensitive user data with ByteDance or anyone else, there's nothing in the record that suggests they even considered it. And that's why it would fail under even intermediate scrutiny.
We have a different problem, which is that the record shows that there is no sharing that could happen that wouldn't put the data at security. But we can go past
That's incorrect, actually.
that. No, because the NSA doesn't. What's very
I'm not
clear-
talking about the NSA.
or even anything else. But putting that aside, one last question. Assuming that the covert manipulation issue is one, I think that what remains is, to the Chief's question and Justice Alito's questions, if the covert manipulation is a concern, then the question becomes what kind of burden does it put on TikTok USA? And I think your point is that that requires strict scrutiny because it doesn't permit them to speak to the Chinese government through the algorithm and promote whatever speech it wants to promote through the algorithm, correct?
It doesn't permit them to speak to the American public through the algorithm.
Right.
And promote whatever type of speech they want to promote on the algorithm. And I also think that this covert manipulation is a little bit odd. They're not concerned just with covertness. If all you were concerned
I'm going to
with
ask
was secret.
She about that. How do you disentangle the two things?
Thank you, Your Honor.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
On
Anybody
the
else?
data collection interest,
Yes,
I
apparently.
think Congress and the president were concerned that China was accessing information about millions of Americans, tens of millions of Americans, including teenagers, people in their 20s, that they would use that information over time to develop spies, to turn people, to blackmail people, people who a generation
think
from now will be
blackmail
working in the FBI or the
Is
CIA
a real concern
or
here.
in the State Department.
I think that is
Is
a
that not a
large,
realistic
concern.
assessment by Congress and the
I think that
president
is a
of the risks here?
real and large
Your Honor,
concern
I'm not
about
disputing
blackmail.
the risks. I'm disputing the means that they've chosen. One way, the most direct way to address that, all of this user data sits on data servers in Virginia controlled by Oracle. I'm not talking about the national security.
Well, there's where it's
What I'm
hosted.
talking about is a law
Oracle,
that
Virginia.
simply says to TikTok Incorporated and its U.S. employees, You cannot share that user data with anybody. You can't give it to ByteDance. You can't give it to China. You can't give it to Google. You can't give it to Amazon. You cannot give it to anybody under threat of massive penalties. They never even considered that most obvious alternative. And so whether you apply intermediate scrutiny or strict scrutiny, it's not a least restrictive means test.
So he's saying even under, it's not the least restrictive means if you're at strict scrutiny, but even if you're not, I don't think his argument on intermediate scrutiny is good. But even if you're not, he's saying it's not substantially related. It is, but these are the security risks that are going to keep coming up. And for all of you who are saying, why aren't you concerned? And I see it. Why aren't we concerned about other apps? Other apps aren't at question today because they are US owned, and that is different. There are other avenues for imposing the laws of the United States against other companies, different than foreign-owned companies. All we're talking about today is TikTok. So he's saying, look, the data from US TikTok is on US-based servers in Virginia owned by Oracle, US company. So banning it outright is not the least restrictive means here. So the law should be found unconstitutional, TikTok's argument, and therefore allowing TikTok to stay because there are other ways to address this. And that's the argument. There are other ways to address data of US citizens.
But you got to at least consider the most obvious alternative.
So you acknowledge the risk that Congress and the president were concerned about. You're just saying the means they chose to address that risk were incorrect,
so
not permissible.
I certainly acknowledge the risk, but I think there are lots of reasons, not just the one I just gave, but there are lots of reasons why that risk still can't justify the law. When it sits alongside of the impermissible covert manipulation risk, I think it falls under Mount Healthy. It's no different if they came in and said, we passed this law, one for data security.
I understand that, but just on the data collection, that seems like a huge concern for the future of the country.
And Your Honor, again,
that's why the court's
it is a
asking the attorney.
concern, two responses. First, it is a concern that can be addressed directly. The reason why there's no evidence in this record about whether that kind of direct prohibition on TikTok Incorporated from sharing sensitive user data with anybody, including ByteDance, the reason why the record is devoid of any evidence of that is because Congress never considered the other side of the balance. And that's the minimum that Congress has to do under the First Amendment. It's got to at least consider the consequences of shutting down a speech platform used by 170 million Americans against the benefits of an alternative, like simply saying to TikTok's employees, you're essentially going to get massive fines, potentially jail sentences, if you share any of that sensitive user data with anybody. Not TikTok, not ByteDance, not China, not anybody else in the world. Yet there's nothing in this record that suggests they even considered that alternative.
What happens after January 19th if you lose this case? Can you just spell that out?
At least as I understand it.
For everybody who's like, well, what's going to happen next? Here we go. Here's what's going to happen next. This is the lawyer for TikTok explaining to us, okay, law goes into effect January 19th. Then what?
We go dark. Essentially, the platform shuts down.
Unless there's a divestiture.
Unless there's a divestiture, unless President Trump exercises his authority to extend it by night. But he can't do that on January 19th. On January 19th, we still have President Biden. And on January 19th, as I understand it, we shut down. It is possible that come January 20th, 21st, 22nd, we might be in a different world. Again, that's one of the reasons why I think it makes perfect sense to issue a preliminary injunction here and simply buy everybody a little breathing space. This is an enormously...
What do you mean by shut down, too? Can you just spell that out?
Yes.
So...
if you...
The app is not available in the app stores. That's at a minimum. But in addition, what the Act says is that all of the other types of service providers can't provide service either. Now, there's enormous consequences for violating that for the service providers. So essentially, what they're going to say is that, I think we're not going to be providing the services necessary to have you see it.
Right.
So it's essentially...
It's likely that the servers will also say the juice is not worth the squeeze in this circumstance. So out of the App Store, 100%, But if the servers also say, we cannot facilitate this app because the servers don't want to get punished, even if you still have TikTok on your phone, even if you downloaded it before the 19th, if the servers are like, we won't support you, the entire app will just stop working. So it's really going to come down to if Oracle says it's not worth the fines and the consequences. So we will see.
Going to stop operating. I think that's the consequence of this law, which again is why a short reprieve here would make all the sense in the world. It's an enormously consequential decision.
They're asking for a reprieve for a day or two.
And I think all would benefit if it weren't necessary.
Thank you.
The Justice Department's going to still say this law passed.
I just want to, it's kind of following up on Justice Kavanaugh's questions. Let's say I agree with you that some level of scrutiny applies, and I'm trying to figure out which level of scrutiny applies, and I'm trying to figure out if there's content discrimination. And let me ask you a different question than I did before.
Sir, you never answered ACB's questions earlier about content discrimination, so ACB would like some answers now. So what happens on the 19th? TikTok US will go dark. That's what he said.
About the algorithm. I mean, you keep saying shut down. The law doesn't say TikTok has to shut down. It says ByteDance has to divest. If ByteDance divested TikTok, we wouldn't be here, right? If ByteDance was willing to let you go and willing to let you take the source code with you, that would be fine, right? We would not be here.
Well, Your Honor, if ByteDance divested, then the law wouldn't fall on TikTok. But the law will, not ByteDance.
But that's because of ByteDance's choice, right? I mean, this is like Justice Kagan's point. I mean, I'm trying to figure out how we account for the reality of third-party choices and the choices of third parties that the whole reason for the law being passed in the first place.
Yeah, Your Honor, I still don't, I think that the way the analysis works is step one, is there a First Amendment violation?
Right.
Step two, you get to the question that we're grappling with. What standard of scrutiny do you apply? Typically, what you do is you ask, is this law content-based? Is it content-based based on its face? Is it content-based in its decision? Here, we know it's content-based on its face because it says what it says. We know it's content-based in its motivation because the government concedes it's content-based in its motivation.
Well, that's not quite what I'm asking. I mean, let's see, that's the dispute between you and the government. Is it content-based if it's about divestiture and not about telling TikTok what content it can display on the platform?
And I think it has to be.
So remember, for the law to be unconstitutional, it has to infringe on a fundamental right. Well, not necessarily. There's other ways we can get there, but they're trying to get to the heart of this. And Barrett is asking, but if this goes to who owns it, then it is not a content-based restriction. The restriction is over the ownership, not what the content on the platform is. And if the restriction is over the ownership, not the content on the platform, then we're not in strict scrutiny. There's not a right impinged, and it's not unconstitutional. So that's where they're going. That's where they're going in these questions. And I agree with the question. Thank you. It's a good question. If it's about ownership and ByteDance has a choice that they don't like, then it's not about the content.
Because I think that really goes to the first question. Does the burden fall on the speaker? If the burden falls on the speaker, that triggers the speaker's First Amendment rights. But the law is in fact content-based, whether it comes in the form of a divestiture or something else. When the law specifically says it's content-based, we're worried about the content on the platform. And when the government tells you that one of our reasons, one of the things that we're worried about is TikTok, not ByteDance, but TikTok Incorporated and TikTok in the United States will, absent the divestiture, have a mix of content that we find objectionable.
And he is arguing it is about the content, or to Tony's point, it is about the pasta. He's arguing it is about the content because he wants it to be about the content. Because if it is about the content, then we get to the First Amendment, then we can get to the strict scrutiny, and the strict scrutiny presumes unconstitutionality first. If it's not about the content and it is about the ownership, then it's just, okay, ByteDance, you have a choice. Not all choices we like. Sometimes there are choices and options, and all of the options are shit. We're adults in this chat. Tell me you've never been in a position where you're like, I have multiple choices here. All of them are shit. That's really where ACB is pointing at. It's like, you just don't like your options, but you have options and the options are over ownership. And he's saying, no, it's about the content. It's about speech. So interesting.
On their videos in a way that is too pro-Chinese or too anti-American.
Okay,
and
let
that
me
is
turn on my
TikTok's
computer, 'cause now I'm getting
platform.
Let me just ask you one last question. Why is it impossible to divest in the 270 days, even assuming that the Chinese government hadn't said you couldn't?
Sure, and this is the exchange I was having with Justice Gorsuch. There are two basic reasons. The first is that the underlying
Because they're not
source
going to be allowed
code,
to.
that's the source code that comes in here and then has to be converted.
But
and
that's what
executed
Justice
in
Gorsuch
code.
said, just not.
Did you catch what she said? What she said is, why is it impossible to divest in the 270 days that they had when the law was passed, assuming that the Chinese government didn't tell you that you can't? Part of the issue with the divestiture is that the Chinese government said, what you're not doing is taking this algorithm anywhere else. No one is getting access to this algorithm. What will likely raise the question for the government is the same way the government likes to get their hands on and break down technologies from wherever else. They would like, I'm sure, to have a US company or themselves get their hands on this algorithm to see how it works, right? They want to take a look at what it's actually doing. And the Chinese government is like, you're never getting your hands on our algorithm, so you're not getting your hands on this company, so we're never going to divest and we're never going to give you our algorithm and you're not going to get to go through it. Jessica asked in the chat, can they not get a new algorithm? They can get a new algorithm. They don't want to get a new algorithm. That came up with the justices earlier. Can't you get a new algorithm? And that's part of the thing. They don't want to. Their algorithm is what makes TikTok different. And anyone who uses TikTok vis-a-vis Facebook Reels, Instagram Reels, YouTube Shorts, whatever, you know as a user intuitively that that algorithm hits different. So it's really interesting to see how that question comes about with, so why couldn't you divest, assuming that you weren't told you can't? Because isn't that the heart of the issue here?
Ever. So it's not really that you can't do it within the time frame. It's that you really couldn't ever divest because you never are going to get the source.
So, well, let me unpack that a little bit. No, it's that
That's exactly
the
what it
underlying
is.
source
She's
code,
exactly
it takes
right.
a team of engineers to update and maintain that. It would take us many years to reconstruct a brand new team of engineers to do that with respect to the source code. With respect to the sharing
never
of
getting the
content,
source
that was
code.
the different reason. In theory, we could kind of send our salesmen around the world, go to Ireland, go to Finland, go to every country and say, look, you used
don't wanna
to
change the source
automatically get our content, but now you got to separately sign up
Okay,
for
so
our platform.
Last point, let me make sure I understand what you're saying. It's not that you couldn't execute the disentanglement. You could say, we're independent. You just can't recreate
like a celebrity
TikTok
divorce.
in any kind of way.
Well, I think that any new TikTok would be a fundamentally different platform with different content, which is yet another reason why I think this is a content-based restriction that falls
Interesting.
directly on TikTok incorporated itself in our platform.
Justice Jackson?
So I guess I'm back to some of the questions that Justice Barrett and Justice Kagan asked about the sort of threshold issue that you point out, which is there a burden on the speaker? I'm trying to understand what the burden is.
I think this is the first time we've heard from Jackson this hearing
and whether
so far.
it really isn't about association and not speech. You say you have in your brief some cases that talk about American speakers being free to choose whether to affiliate with foreign organizations, and the colloquy you had with Justice Kagan made me think that what you're really complaining about is the inability to associate with ByteDance and its algorithm. That it's not really about, if TikTok came up with its own algorithm or bought an algorithm from some other company or devised it or whatever, this law would have nothing to do with it.
So for everyone who asked, why can't they get a new algorithm? She's breaking down what the core of their argument is regarding that, is that what they're saying, what they're complaining about ultimately is, hey, it's not that you can't get a new algorithm, it's that you don't want to.
from your perspective. But the problem I think you're articulating, and this is, I'm seeking your clarification.
Sure.
The problem I think you're articulating is that you want to use ByteDance's algorithm and therefore associate with ByteDance, and Congress has prohibited that by requiring divestiture.
Right.
So isn't this really a right of association case under the First Amendment?
I think it's both, Your Honor. I do think that that is a component of it. We want to use the algorithm that we think reflects the best mix of content. That's the algorithm that reflects the best mix of content. What this law says is we can't do that unless ByteDance exercises a qualified divestiture. But I also think more directly what this law does is it says to TikTok Incorporated, if ByteDance doesn't exercise a qualified divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says that, though. I mean, if TikTok were to post divestiture or whatever, pre-divestiture, come up with its own algorithm, right, then when the divestiture happened, it could still operate. It doesn't say TikTok, you can't speak.
I think that's theoretically correct, Your Honor, but I think that also
Right.
underscores the content-based.
Right. I think that's theoretically correct, Your Honor. Right. We just don't fucking like it. Right. Right. TikTok is not being prohibited from speech. You want the ByteDance algorithm. The ByteDance algorithm means you have to associate with ByteDance, or they have to give it to you and let a US company also own that algorithm, which they don't want to do. Or you could get another algorithm, which they don't want to do. So they're like, I don't like that option. And she's like, but the option is an option. So not really saying you can't speak, saying you have to change the way you operate. They don't want to change the way we operate. Right. And he acquiesced on that.
Exercise a qualified divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says that, though. I mean, if TikTok were to post divestiture or whatever, pre-divestiture, come up with its own algorithm, right, then when the divestiture happened, it could still operate. It doesn't say TikTok, you can't speak.
I think that's theoretically correct, Your Honor, but I think that also underscores the content-based nature of the restriction.
No, but the fact that that's true suggests that you're wrong about the statute being read as saying TikTok, you have to go mute.
Go on, Judge Jackson.
Because TikTok can continue to operate on its own algorithm, on its own terms, as long as it's not associated with ByteDance. So isn't this really just all about association?
Your Honor, I think it is partly about association, but I'm going to take another shot at explaining why it's not just about association.
No, I get it.
Well, let me just take you down the association path for a second, because if it is about the association of TikTok with ByteDance, then don't we have cases that seem to undermine your view that Congress can't do this? I mean, I thought we had cases about Congress prohibiting association with terrorist organizations, prohibiting association with foreign adversaries. And so why doesn't this fall into that kind of group of our jurisprudence?
Well, at least as I understand all of those cases, they applied strict scrutiny. The material support statute most definitely applied.
And ultimately upheld the law, so fine.
But sure, and I think if we go down the strict scrutiny road here, I don't see that this law can possibly be satisfied under the interests that they assert here. But I do want to emphasize why this is also
for
about...
all of you saying it doesn't seem like it's going well for TikTok, when we're looking at appellate arguments and Supreme Court arguments, it should feel like it's not going well for the attorney in the hot seat. So it's going to feel like it's not going well for TikTok here, and then the government's going to get up and talk, and it will likely feel like it's not going well for them. That is the role of these judges. It's going to be like, ooh, they are all against him. And then the next speaker is going to get up and you're going to be like, ooh, they are all against you. That's it. They're against everybody. The role of the appellate justices in the Supreme Court is I have questions and I'm going to ask you the hardest questions possible. And you shouldn't be able to tell really which side they're on. Sometimes you can. Sometimes you can't. But hard questions for everybody is the goal. So we're not even to the government's arguments yet.
TikTok speech. Even under your hypothetical, where theoretically they can say something differently than they are saying today. That in and of itself is a direct restriction on TikTok speech. They can't engage in the speech they want to engage in. They have to engage in a different kind of speech, the speech they don't want to engage in. That is a direct burden on TikTok incorporated speech.
All right, I think I understand that argument. Let me ask you a question about your colloquy with Justice Kavanaugh. Did I understand you to concede that there is a compelling interest and that the problem is really tailoring? I mean, you said, I understand the risks. I don't hear you suggesting that the risks don't exist. So it sounds like we've gotten past, even if we're in strict scrutiny world, we've gotten past the compelling interest part of this.
No, Your Honor. What I was saying is that all you had standing alone were the data security. That would be a different case. Here, when you have the content manipulation sitting right alongside of the data security, that taints the data security rationale. If Congress came in and said, we're passing this law for two reasons. One, we really care about data security, and two, we hate the speech on TikTok. The data security wouldn't alone sustain that law under cases like Mount Pleasant.
I understand, but why you're equating we don't want foreign adversaries to be able to manipulate the content on this platform. You're equating that with we hate the content, and I'm just trying to understand why.
Because content manipulation is by definition a content-based distinction. Look, everybody manipulates content. There are lots of people who think CNN, Fox News, the Wall Street Journal, the New York Times are manipulating their content. That is core protected speech. That's why they put so much weight on this mere covertness.
Right, but that analysis is just about content-based versus content-neutral, and therefore whether you apply strict scrutiny. I'm in the strict scrutiny world, okay? I'm assuming
I'm with
that
you.
You're right, that strict scrutiny applies, and now prong number one in that world is, does the government have a compelling interest? And so I'm trying to understand why the government's argument that we have data manipulation concerns, which I understood you in colloquy with Justice Kavanaugh to say is a risk, and we are concerned, based on what Justice Gorsuch says when he's looking at the facts, that the government contends that there's this real problem with this foreign adversary doing manipulation in other places. Are you saying those are not compelling government interests?
I am 100% saying that content manipulation is not just not a compelling governmental interest, it is an impermissible governmental interest. You could not go to CNN or Fox News and say, we're going to regulate you because you're manipulating the content in the way that we don't like. That is per se impermissible.
Sued.
Okay, can I just ask you one last thing? You say, with respect to the tailoring issue, that disclosure, you think, is a possible, more narrowly tailored way of handling some of this. And I guess I'm just wondering whether disclosure under this court's case law and the law of other lower courts doesn't carry its own First Amendment complications. That wouldn't we have compelled speech problems if disclosure was required in this situation?
Sure, Your Honor. Now, look, I might think so because I think that the factual predicate is wrong, but they think the factual predicate is right. And if the factual predicate is right, then there are no First Amendment problems at all under Zauder and the cases that you're suggesting. And that underscores the larger problem here. Not all disclosures are perfect. I'm not here to argue that they are. But you've always got to consider what the alternative is. And here the alternative is shutting down one of the largest speech platforms in America. The reason there's no evidence in this record as to disclosures is because Congress never even undertook that balancing in the first place.
Thank you.
The bare minimum that has to be done before we take an unprecedented step
that
of shutting down.
That thank you was very much a stop talking. Because not answering the question, because the answers don't go well for TikTok if the questions are answered directly. And the courts are like, thank you, done, just done, just done, just done. TikTok is trying to say that this is speech-based, and the court is saying in various different ways, isn't it targeting these things? And he's like, we are forced to shut down. And multiple justices have said, no, you have options. You don't like the options, but you have options. And they are saying we are being forced to shut down. And they are saying, no, you're not not being forced to shut down. And I'm very curious to see when they get to the government, the questioning there, because numerous justices have said your option is not the government is forcing you to shut down. The government is forcing you to divest, and that's different. And if the Supreme Court continues to follow that thread, the answer is that this law is constitutional.
Down the voices of 170 million Americans.
Thank you.
Thank you, counsel.
Done. All right, moving on. I imagine they'll let the second attorney speak for the content creators next. That would make sense to me.
Mr. Fisher?
Mr. Chief Justice, and may it please the court, wholly apart from the companies.
Mr. Fisher is the attorney for the TikTok creators. There are two cases here that are consolidated. One is TikTok Inc., the US-based company of TikTok. The other is the TikTok creators, and there's 5 or 6 creators that sued. So there are numerous creators that sued. Jeffrey Fisher is the attorney for the content creators, saying that their speech is being infringed upon by this law. And this law, as it applies to the content creators, is unconstitutional. So we're going to get similar but different arguments here because we're coming from the perspective of the content creators. And I don't know. Michael asked any famous creators. I'll read you the names of the creators in a minute. I'll pull up the document directly. So the lead creator's name is Brian Firebaugh, but I'll pull up the name of the other creators. The problem I have with short form content is I know them by like the thing that they do. I don't always know short form content creators by name, which I feel horribly about. But it's like, oh, the content creator that does this one thing. So now we're going to get into the arguments for the content creators.
Legal interests here. The Act directly restricts the rights, the First Amendment rights of American creators to participate and speak in what the court a little less than a decade ago called the modern public square. And what you might say today is the most vibrant speech forum in the United States of America. And the Act, therefore, is inescapably subject to strict scrutiny because of the First Amendment implications. And the Act fails that test, and indeed any level of scrutiny under this court's case law, because the Act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with this implication and its use of the phrase national security in this context. But that just simply doesn't change the calculus. Throughout our history, we've faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow doubt about our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the court should reverse, and I would welcome the court's questions.
How exactly are the creators' speech being impeded?
So 2 ways, Justice Thomas. First, I just point you to the text of the statute, which directly regulates text, images, real-time communications, videos. My clients, the creators, are the ones creating that speech and posting it to speak to other Americans.
But it doesn't say anything about creators or people who use the site. It's only concerned about the ownership and the concerns that data will be manipulated or there will be other national security problems with someone who's not a citizen.
Thomas, you question solely. I'm interested to see if we get to, but creators can still speak on TikTok if TikTok chooses to divest. TikTok has a choice. TikTok can choose to divest from ByteDance, or they can choose not to. So really, TikTok is the one making the choice. The government isn't forcing TikTok to do anything. The government gave TikTok a choice. TikTok can choose to divest. TikTok can choose a different algorithm, or TikTok can choose to shut down. So really, this has nothing to do with the creators. This is TikTok's choice, and they don't like their choices. So it's interesting to see. But Thomas asked at the beginning, at the very, very beginning, asked questions with the last attorney, and I'm not surprised he's up first, and then I think he'll probably be done. He's like, I'm up first, and then I'm out.
of this country or a company that's not here.
So there's two ways, and I think the Sorrell case is where you look for the analysis of the First Amendment burden here. As I said, the text of the statute regulates our speech, and then you point out ownership, and this was talked about a lot in the first part of the argument here, so let me be very clear. The American creators have a right to work with the publisher of their choice. So imagine somebody wanted to work on post speech on Twitter, now known as X, and Congress passed a law saying, we don't like the current owner of X. The current owner of X has to sell that platform or else it has to shut down. People who post on that platform and who indeed some of them make a living commentating, engaging on current events, news, politics, would have a First Amendment claim to work with
using
that
that argument, you could have said that about the breakup of AT&T. You could say that about the foreign limitations on foreign ownership of broadcast companies.
Well, no, I think that you have to dig a little deeper than that, Justice Thomas. It's not mere foreign ownership, and it's certainly the broadcast cases I'll get to in a moment, but it's foreign ownership because of a particular perspective. If you boil it down to an essence, the owner of a print media or online media publication is the essence of the viewpoint of that publication. The current owner of X or the current owner of Fox News or the current owner of MSNBC has a particular perspective, and working with that particular platform is shot through with the ownership from top to bottom.
But why couldn't Congress prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States? I mean, I thought that's what Holder versus Humanitarian Law Project allowed. So I don't really understand what you mean.
Right. So I'm glad you're bringing that up.
Yes.
So when it comes to this national security, you are right that Congress can prohibit Americans, to use that case as an example, from associating with terrorist organizations or other organizations that pose a clear and present danger to this country. This case, Justice Jackson, is fundamentally different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine U.S. leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, and this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, and I think the place I would point you most directly would be the opinions of Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't understand how that's distinguishable.
They changed. Did you hear the lawyer change the argument? The lawyer changed the argument. And the argument here is, hey, they're arguing that speech is being impeded. They're arguing that the government can't restrict who somebody chooses to associate with or do business with unless there's a security issue. But the heart of what the government's case is here is that there's a security issue. So they keep trying to shift it away from that underpinning, saying, no, this is about content. They're trying to shut it down because they don't like what could be said on the platform. But the government's underlying argument is, no, this is a security issue. And if we're analogizing security issues, then can't we analogize between this and a different security issue? Because that's the government's argument here. So he keeps shifting it to, this is a content-based restriction. They don't like what's being said on the platform, versus the government's argument of, we don't like what data is being collected and who accesses it on the platform. And we don't like the fact that there can be content manipulation. So they are trying to argue the two ways. I see some of you in the chat saying, but there isn't a security issue. Well, that's not what's the question here. We're not the arbiters of truth on whether there is or there isn't. Congress is the arbiter of that, and Congress passed a law saying it. The Supreme Court is trying to determine whether or not the law going to the stated purpose is constitutional. The problem is we don't have all of the briefing on it because a lot of it's redacted because it is security. So Congress gets to decide if there's a security issue. You don't have to agree with them. The Supreme Court has to decide if the law is constitutional or unconstitutional based on the stated purpose, but they're not going to underlie it. So we're at the Supreme Court level. The lawmaking already happened. So it's fine to be like, right, but I don't agree with the basis of their law. Fine. That's not what the Supreme Court's here to do. They're here to say the stated basis is this. Is that constitutional or unconstitutional under strict scrutiny? So there's different questions here. So we haven't gotten to the government argument yet, but we will.
From what's happening in Holder, so can you just say a little bit?
It goes to the nature of the national security threat. So my position is the government just doesn't get to come in and say national security in the case is over, or you don't get to associate. You have to dig underneath what is the national security claim. And what Justice Holmes said in his Abrams dissent, and I know that was a dissent, these are hard issues, but that has been vindicated over time, is that it's not enough to say national security. You have to say, what is the real harm? Is it, is it terrorism?
You can't just say words.
Where our battleships are located? Is it war?
Justice Kavanaugh presented a number of potential risks.
You can't just say words.
Right, with foreign adversaries using covert manipulation of the data platforms that are being used by youths today that would then make it more likely that people would turn into spies and do terrible things to the United States. This is a hypothetical, but you know what I'm saying?
Happened
I get
against
it.
Google.
So I think if I understood Justice Kavanaugh correctly, he was talking about the data security argument. So let me just pull these apart. You first have an argument, and the government itself separates these two arguments in its brief. The first argument, the one I'm focusing on initially, is the content manipulation argument. And that argument is that our national security is implicated if the content on TikTok is anti-democracy, undermines trust in our leaders. They use various phrases like that in their brief. So my primary submission is that is an impermissible government interest that taints the entire act. Now there's a secondary argument the government makes, and we say you don't even get to that because once you have an impermissible motive like that, the law is unconstitutional. But even if you could get to that, Justice Jackson, I do grant that data security and the way Justice Kavanaugh spelled it out is compelling. That is compelling, but that's not the question. You just don't ask in the air, was Congress worried about data security or could it reasonably—
No, we don't ask in the air. We throw our hands in the air. Either like we just don't care or we throw our hands up in the air sometimes. Either way, I love how fast Fisher speaks, but what Fisher is saying, yes, if there is a security issue, then it might be a compelling government interest, right? This all goes back to strict scrutiny. There has to be a compelling government interest. But he's saying you can't just say magic words and then it magically becomes a compelling government interest. And really, that's not their interest because the government can't just say, hey, security, and everybody goes, oh, okay, it's fine. We don't evaluate it more. So what he's saying is you have to go beyond that and say, is that really the compelling government interest? Is that a compelling government interest? Or is this going directly to content and them trying to control content and them trying to control speech? So this is the fight here between the two, and the justices are asking, but assuming security issue, because law's been made, assuming that, then this. So that's why we are going forward in this manner. But he keeps trying to shift the conversation back to content, not to security, because security is always going to be a compelling government interest. He doesn't want to lose that prong.
Be worried about data security, you say, can this act, the act before you, be sustained on data security grounds? And our answer to that has to be no. You don't have to look any further than the divestiture provision itself, which says that the content recommendation algorithm cannot be used in the future. Well, that has nothing to do with data security. So the core feature of
the government can't just lie.
Divestiture provision is going at content manipulation, which I said is impermissible. You can't uphold that under data security grounds. And the rest of the act, when you look at the covered companies provision, Justice Jackson, if this were primarily a data security law, what you think you'd find is what kind of data is procured? How is it stored? Is it shared? Those are the things you think you'd find under covered companies, but you don't find that. What you find is, are text images shared? Is content being shared between users? Is it being created and posted in a social media platform? So I don't dispute for 1 second that data security is a very important—
Josh asked, does the Supreme Court get the unredacted version we don't get to see? Yes, they do. They do. So, yes, they do.
thing, and Congress in this very law regulated data security in other ways with data brokers. That's perfectly permissible. But the question before you today was narrower. The question is this law before you sustainable on data security grounds? And that answer has to be no.
Congress doesn't care about what's on TikTok. They don't care about the expression. That's shown by the remedy. They're not saying TikTok has to stop. They're saying the Chinese have to stop controlling TikTok. So it's not a direct burden on the expression at all. Congress is fine with the expression. They're not fine with a foreign adversary, as they've determined it is, gathering all this information about the 170 million people who use TikTok.
Well, again, Mr. Chief Justice, if I may, let me separate
that was Roberts.
Where you started, which was the content manipulation, and then go to the data security part of it.
It's not about the pasta.
So,
well, the first part was not. I'm not talking about the content manipulation. I'm talking about the content harvesting.
When you say content harvesting, do you mean people's data?
They've got all the information, whatever algorithms they want, that has access to the personal information, or at least information that is not readily available, about 170 million Americans. And whether they're going to use it in 10 or 15 years, when those people grow up and have different jobs in different places, or whether they're going to use it now, that, at least as I look at the congressional record, is what Congress was concerned about.
Well, I think
and they're not concerned about the fact that it is available. As I said, the remedy is just somebody else has to run TikTok. So they're not concerned about the content. They're concerned about what the foreign adversary is doing.
So if I may, I think
they're fighting so much over whether this is a content-based restriction and a speech-based restriction is it's going to get to whether or not this is a law that's facing strict scrutiny or not strict scrutiny, and that's where the court is parsing what standard applies. What standard applies very much determines how this goes. And so they are parsing down, is this about data security, or is this about restricting content, which is why Chief Justice Roberts is saying this isn't about what people are saying on TikTok. Nobody cares what people are saying on TikTok. Whether you believe that or not is a separate issue. But he's saying this law doesn't care about what's being said on TikTok. What it cares about is what data is being mined from the app that is not, and he said it in his statement, is not readily available elsewhere. That is the question here. And if that's not about, if the law goes to that purpose, then isn't that A, something that gets out of strict scrutiny, and B, something that doesn't meet and B, even if there is strict scrutiny, then strict scrutiny is met.
To answer your question properly, I think you have to separate two things. One is the content recommendation algorithm. And that's what I was speaking about a moment ago. That has nothing to do with data security. That doesn't itself procure data. That just determines what videos people see on their feed on TikTok. As to that, I think the answer is inescapably that the government and Congress itself was worried about content. The government itself is here saying national security. So like a mix of cat videos
they do fucking care
or
what
dance
we
videos
say.
Doesn't affect national security. No matter what happens,
give me cat videos. Give me cat videos. So TikTok, or the lawyer, this is the lawyer for the creators. The lawyer for the creators coming back saying, oh, yes, they do care about the content on the platform. This is going on with the content. This law is attacking the content. The justices disagree, but then when we see them get to the government, we'll see the arguments there.
The only thing that can affect data security, national security, are the substance of those videos. And when the government's pressed in its briefing, it outright tells you that. It says what we're really worried about is sowing doubts about U.S. leaders, et cetera.
That's a good argument. That's a good argument. That's a good argument. When he's saying what is the security concern, he's arguing, well, the security concern is what's being said in the videos. Therefore, it's the content. What they're going to shoot back with is, but they're saying it's about data mining, not about what's being said in the video. He's saying, but what are you worried about if not the words that are coming out of somebody's mouth in a video? That's a good argument. I appreciate that argument.
To data security. Yes, there were various congresspersons, and in the record that we have in the D.C. Circuit, there were conversation about the problem of data security here. As I said, I don't dispute that that is a valid governmental interest. So I think you addressed whether that alone can sustain the act in two steps. First, you would ask if you have an
So he's now addressing the direct question of, if this law is just about the data, the pasta, if this is just about the pasta, if this is, and all of you in the chat can go on and say, it's not about the pasta. I get it. If this is just about the pasta, the data here, then is the data a compelling government interest? And both lawyers have conceded, yes, it is. That's a compelling government interest under strict scrutiny. So if it's just about that, then does this law still fail? And he's going to break that out in two parts. He just said so I hope he does. But the justices keep asking, can the law stand up if it's just about the data? They keep hearkening back to the data is kind of an excuse. It's not really about the data. The data is an excuse to say, hey, we're doing this thing that's unconstitutional, but we're saying it's because of this to make it seem okay. But what we're really doing is infringing on free speech in an impermissible way. And we're just kind of trying to make you look over there to say that it's okay. So that's why the lawyers keep coming back to, no, this is about the content. It's about what's said in the video. And the justices keep asking, isn't this really about the data? And it has nothing to do with what's being said in the videos.
Impermissible motive and a permissible one. Can we sustain the act based on the based simply on the permissible motive? And I think for the reasons Mr. Francisco said, and we lay out in our brief, that alone, the answer is no under Hunter against Underwood and other cases. Even if you could get just to the data security question, again, you'd have to ask the question, would this law have been passed by Congress for data security reasons? Because you're being asked to uphold a law based on that single governmental interest. And when you look through the provisions...
Yes, all of you can just ask the reasonable question. But if Congress was really worried about data security, wouldn't they just pass a law that applies to all social media platforms? I understand that that is a very reasonable question, but that's not what they did. So that's not where we're at. What we're at is trying to do this. But yes, reasonable question. Will they ask? Maybe, but we'll see.
Like the content recommendation algorithm provision, like the covered company provisions, the answer is no. And if you're still in doubt on that, just go back to the under-inclusiveness problem. Would a Congress really worried about these very dramatic risks leave out an e-commerce site like Temu that has 70 million Americans using it and every bit the connection?
Does Congress have to go all or nothing on that? I mean...
That's the question. But would it leave out Temu? Now Temu's in the chat, but would it leave out Temu?
It doesn't have to go all or nothing.
They isolate a particular problem, and they might be getting to what you're talking about next. Who knows? But you're really sitting up there and saying Congress would not pass the divestiture law if data security were the only interest.
That's what he's saying.
So I'm saying it would not have passed this divestiture law if data security
That's exactly
were the
what he
interest.
said.
It's very curious why you just single out TikTok alone and not other companies with tens of millions of people having their own data taken, in the process of engaging with those websites and equally, if not more, available to Chinese control. So I'm not trying to say that Congress has to do everything at once. I'm trying to say that once you've concluded that content manipulation, for the reasons I've said, as a matter of our history and tradition, has to be impermissible.
Is there another site like this one that covers half the American population? Okay.
I don't think just by way of sheer numbers, Justice Sotomayor, that the answer has to be no, but 70 million seems like a lot.
170 million is a lot.
The answer has to be no. Is there another site like this one? The answer has to be no.
But put that aside and then go to the next question, which is, how many of these sites have all of the data collection mechanisms that TikTok has? From what I understand from the briefs, not only is it getting your information, it's asking, and most people give it permission to access your contact list, whether that contact...
Man. I'm going to let him answer. I'm going to let him answer about what all the other apps do, because she's asking about what all the other apps do. He's going to answer about what all the other apps do, because, ma'am.
Seems like a lot.
170 million is a lot, but put that aside and then go to the next question, which is, how many of these sites have all of the data collection mechanisms that TikTok has? From what I understand from the briefs, not only is it getting your information, it's asking, and most people give it permission to access your contact list.
Most apps do.
Whether that contact list has permitted them to or not. So they can now have data about all of your contacts and anything you say about them. How many other sites gather information by keystrokes to be able to do voice and finger ID information if they choose. And there's a whole lot of data stuff that was discussed in the brief that I don't think any other website gathers. So wouldn't this be a unique site? If I viewed the evidence that way, how would this be under-inclusive?
Justice Sotomayor, I don't think a lot of the suppositions you're making actually bear out. And as Justice Gorsuch was pointing out, one of the, obviously, the real challenges in this case is it comes to you without an ordinary trial record compiled and all the rest. So we have only limited amounts of information. But absolutely, these other websites are taking much the same kind of information, if not more. And as to the contact list thing, I think you also, that points out one other aspect of this. That is voluntary decision by an American user to share.
Well, one of the issues with TikTok in the past, and I think this has been fixed because there were multiple lawsuits about this. One of the issues with TikToks in the past was that even if you said, no, you can't access my contacts, they just did anyway. So there have been past issues with this, but now it is an opt-in.
Share that information. You know, in the Riley case.
But not informed. And
well,
even if informed,
that could be solved. If you don't think it's informed, that could be solved by a warning or disclosure.
No, that can't be, because for the United States, the threat of using that information is what is at issue. It's not whether the user thinks it's okay. It's whether the U.S. believes that it could put sites at issue. But let me ask you one last question and fundamental question. Assuming that content neutral data collection concerns were the Congress.
It seems that we are moving on from this line of questioning, but I'm surprised that this attorney didn't take the opportunity to say, by the way, this is what other apps do, because I think there's quite a lot of information out there about what other apps do. We're moving on from that, but I'm surprised. Also, I will say, to be fair to the attorneys here have not had as much time as they normally would to prepare oral arguments for the Supreme Court. So these attorneys were on a tremendously shortened timeline because the court agreed to take this up on an expedited matter. The court doesn't even really come back into session until next week. So the attorneys are on a shortened timeline, and to verify that in the way that you would need to verify it to tell the Supreme Court that that is true, they might not have had time to do that. The attorney can't just, on information and belief, Facebook, Instagram, Google, all. They would have to have quite a lot of information to back that up before they could share that, and they might just not have had time to do so. So to be generous there, but we're going forward, it seems, into a different category. But when the court's asking, isn't this app unique in the data they collect? Maybe in some ways, but you wouldn't, you're law nerds. There are quite a lot of apps that collect quite a lot of information in ways that, if you don't pay attention to this stuff, would probably stagger and shock, but that is all. So we'll see.
Congress is one of Congress's provisions, divest because of this. Why can't we separate that out from how we analyze the algorithm question?
That's interesting.
And couldn't we sever the two provisions to say divestiture is right, but you can't force them not to discuss algorithm?
Well, I think the reason why you can't do that was Mr. Francis.
The court is asking, why can't we separate this into two parts, saying you have to divest ownership, but you can still use the same algorithm? Why can't we just do that? Which is interesting. And again, it's generally not the role of the courts, in my opinion, to fix the law. They can say constitutional, unconstitutional, Congress go back and do it again. But oftentimes the court will try to parse it out and say this part will stand, this part won't. And yes, they can do that too. They can splice it and say this part finds, this part's not. So we'll see.
Cisco explained. I thought I'd direct you to a case like Hunter against Underwood and just analogize it to this situation. If what you had is the government saying, we are shutting down TikTok or requiring divestiture for two reasons. One, because we think it helps the Democratic Party too much. And number two, because we're concerned about data. I think that first interest would be a poison pill. that would be an impermissible, or because we think there's too much pro-Catholic content on TikTok. I think there are some interests that are just so constitutionally verboten that I think that just makes the act unconstitutional, and you can't go looking for other interests.
I don't know what algorithm they all are on.
If you want to pass a data security law,
I clearly, and I do not have TikTok on my devices, but I clearly have trained my algorithms better because cats and spicy books. So I don't know what side of the algorithm you ended up on, sir, but my TikTok, there's times when I look at my algorithm and I'm like, I am married. What are you doing? But the spicy book sometimes launches you into other stuff. However, we are going to see those arguments coming up because of course, but I don't know how we got down the rabbit hole well, I do know how we got down the rabbit hole. They're trying to get back to that this is content based.
Free and clear of this impermissible
and
interest.
Yes, verboten is fantastic.
So, can I say one other thing, Justice Sotomayor, just because I think it is
Sotomayor is like
also tell.
When they say thank you, they want you to stop. Can I say one more thing? Nope.
Here that even if you didn't buy that poison pill argument and you just asked whether Congress would have passed this law, something else that I think you might notice is even if all this act goes into effect and the law goes through, TikTok gets to keep all the data. So wouldn't a data security law require them to expunge that data or get rid of it or something? I mean, it's a very weird.
I like that argument. I like that argument a lot. The argument being, but Your Honor, wise court, if this is really about data, wouldn't you have to force them to get rid of all the data? Wouldn't you be focused on the data? If this is not just a smoke screen, then wouldn't you want them to wipe the servers? So isn't this really about the content? That's the argument here. That's a good argument.
Weird law if you're just looking at it through a data security lens, and maybe Congress could do better.
Mr. Fisher, often we require divestiture for antitrust reasons, for example. And as I take it, your argument here, and we don't think of those as normally implicating the First Amendment interests of users or
Judge K is not in that courtroom when nobody says bless you. So we'll aggressively do it here.
Might speak or associate with editors. And the difference here is, as I understand it in your mind, that this law is motivated by a content-based
That's
interest.
his argument.
Is that a fair summary?
Yes.
I think that, and the only thing I would add to it is just the prior step, which it is regulating the speech itself for content-based reasons.
Yeah.
Yes.
That's a fair
We don't
summary.
do that in the antitrust area, but you say this law does. Okay.
Exactly.
And it does on the covert content manipulation side. Do you think that's a compelling interest or not? Forget about the tailoring for a moment.
No, my point is that preventing content manipulation, whether it's covert or not,
is simply not
impermissible. If what you mean by content manipulation are the kinds of interests the government is saying, like undermining trust in our leaders, undermining trust in democracy. That's Whitney and Abrams, and like those cases.
I got it.
Yeah.
I got it. Just a couple more. I'm sorry. I'll finish up real quick. And so that would take us to the tailoring question. And there you say disclosure. And alerting Americans that there is covert content manipulation possibility, putting aside the data collection part of it. Yeah. Telling Americans that there is covert content manipulation going on in TikTok, or at least it's possible. And the government says that's just simply not enough. And the D.C. Circuit did too, and I wanted to give you a chance to respond to that.
Right, so I think that's the only aspect of the governmental interest that could be permissible, the covert part. And my answer, as you just said, is disclosure solves that problem. And you have a long-standing law, which we haven't talked about yet today, that gives you that example. Again, under a history and tradition test, you look at not just precedent, but laws and our traditions of our country. Look at the Foreign Agent Registration Act, passed in the run-up to World War II, and the concern was Americans would be controlled by foreign agents to speak and advocate certain causes.
We didn't ban them.
You did not ban them. All you did is require, Congress, all Congress did is require disclosure.
Certainly I wasn't around for that. On the secret.
Counsel, you will not call me old. I love it when there's moments of levity in court. And I know we don't watch the Supreme Court a lot. Most of the things that the Supreme Court is covering don't really fall into the content that I cover, but I think the questions of speech, First Amendment rights, government control, TikTok, all of it, and social media impacts what we do here. And I'm just really interested in it as well. But I think the question stands with, is this questioning is going to, is this the least restrictive means? Because both lawyers have said a disclosure could work. And that's why they're talking about the Foreign Agent Registration Act, because both lawyers have said, look, it is not narrowly tailored. Couldn't you just say in a disclosure, hey, we're disclosing who has access to the data on this app, and wouldn't that work? So that's why we're getting into the laws back from World War II, with the judge being like, I'm not that old.
Not ban them. All you did is require, you, Congress, all Congress did was require a disclosure.
Certainly wasn't. I wasn't around for that. On the secret evidence
That sounds
point,
like a full gallery.
I'm concerned about the government's attempt to lodge secret evidence in this case without providing any mechanism for opposing counsel to review it. And
this too. Thank you for this question. I was hoping we would get back to this. I'm going to back up so we can do it again, because now it's like, ooh, important. Back up. Let's do it again. A, this sounds like a packed house for this argument, but B, now we are getting to, what about the government lodging secret evidence in this case? Because the redacted briefs aren't just redacted from public view. They are redacted from counsel's view. The government straight up was just like, sorry, counsel, you don't have the security clearance. So what about the government attempting to lodge secret evidence in this case that only the government and the court have, that even opposing counsel doesn't have? So yes, tell me more about that.
On the secret evidence point, I'm concerned about the government's attempt to lodge secret evidence in this case without providing any mechanism for opposing counsel to review it. And I expressed that concern in Zebeda, and I noted that there are mechanisms to read in counsel and that other countries, including our allies, often do that. I just wanted to give you a chance to give me your thoughts on that.
I like this
yes,
question.
Justice Gorsuch, we made all those arguments in the D.C. Circuit, so there was a flurry of motion practice about whether or not the government could rely on classified evidence. Those motions were never resolved. What the D.C. Circuit did, I think you probably noticed from the decision, is say we're going to decide this case solely based on the public record. And my understanding is that's how it comes to this court.
It's
but if the court were ever...
It's interesting that Congress hasn't acted in this field. I mean, we have...
Gorsuch wants you to skewer the government a little bit more, sir. He's like, I've opened the door wide and I would like you to take the opportunity to tell us. And so when he started getting to, well, the DC Circuit Court said that they wouldn't rely on anything that wasn't public record, and then it never got resolved, the court's like, no. I want you to get back to the WTF of secret evidence, please. Can we get back to the secret evidence? And so I think Fisher was being a little bit more generous. And Gorsuch is like, no, I don't want you to be more generous. Or at least that's how I interpreted that.
In the FISA area, lots of opportunity. They have regulated this area, and it does seem like an area that Congress might want to pay attention to, given the increased appeals to secret evidence that the government has made in recent years.
Gorsuch is not happy with that. He's like, this is the opportunity for Congress to hear what we think, because the Supreme Court can't go to Congress and be like, yo, WTF. This is the Congress may want to consider the increased government reliance on secret evidence. We don't love it. And so I'm interested to see if the attorney walks through the door on that.
Last question for you. Could the new administration, after January 20th, Mr. Francisco suggested that it might be able to extend the deadline, even though if you were to lose here by January 19th? Is that possible as you read the law?
I'm not sure it is. I'm not sure. Maybe that's a question for the Solicitor General. But
oh, it certainly is. I thought maybe I'd give you a chance, too.
He's like, let me give you a chance. I don't think there is any mechanism for a new administration to extend the deadline on this. So
As I understand the law, it's 270 days unless extended, and once that time runs, I'm not sure you're talking about an extension anymore.
Okay.
There's ex post facto law that kind of does this
Got
stuff.
it. Thank you.
Can I take you back, Mr. Fisher? Let's say I agree with you that if you're talking about content manipulation, that's an inherently content-based rationale for acting. So if Congress had passed a law that says we hate the content manipulation that TikTok is doing, that's strict scrutiny land, and I don't know that the government can do that, however important and the
By the way, the Solicitor
interest.
General will be
But
up
that's
next.
not what Congress is doing here, and this is the same kinds of questions that I asked Mr. Francisco. Because if let's take it as a given that Congress actually can do whatever it wants with respect to a wholly foreign corporation or a foreign government. And so Congress could act with the intent to interfere with the content manipulation that a foreign corporation is doing. And so now we're in this strange world where we're saying they can't act with respect to TikTok. They could act with respect to ByteDance. Why isn't this Congress acting with respect to ByteDance in the sense that all it's doing is saying ByteDance has to divest, and then TikTok can go about its business, use whatever algorithm it wants, use whatever content moderation policies it wants, just like everybody else does, choosing from everything that's available on the open market?
So let me answer that question in two
Again, can't they get
parts
another algorithm?
from the perspective of the creator Americans who want to use this platform to speak to other Americans. So the first thing is what the act does, as you said, Justice Kagan, is prevent us from working with a application that is owned by ByteDance that uses this algorithm. Well, that's exactly what we want to do. That's our editor and publisher of choice that we think best disseminates our speech.
Yeah, but what I'm saying to you is if you just assume a world without TikTok, that where it's only ByteDance, and you were trying to say, well, we really want to work with ByteDance, and Congress was saying, we think ByteDance presents national security interests, and they don't have First Amendment rights. They're just a foreign corporation. I think that in that case, the government, tell me if you think this is...
This is getting into what Justice Jackson was asking about. Isn't this then really a question of right of association? TikTok Inc. US is saying, hey, we don't want to divest our corporate ownership first, but second, even if we divest our corporate ownership, say TikTok Inc. US sells, the law also then prohibits us from working with ByteDance Inc. Say someone else entirely owns TikTok Inc. US. We still want to work with ByteDance because we want their proprietary algorithm because we think that is our best business decision. And this law is saying not only do we have to divest our ownership, so whoever buys TikTok Inc. buys TikTok Inc., but the law also says, but then we can't, TikTok Inc. US, work with ByteDance for the proprietary algorithm that we want to use. And so isn't this really saying not only do we not get to use the publisher, and they called it a publisher, still shocked, not only do we not get to work with the publisher we want to work with, but we don't get to work with the editor we want to work with, again, calling the algorithm an editor and a publisher. So isn't this going to two tiers? First, we don't have the ownership we want. But even if we sell, the second problem is we can't work with ByteDance. That's who we want to work with. Isn't that really a question of association, which Justice Jackson was asking about earlier? I'm so interested. Okay, we're going to get back to this and see what they say.
Wrong. It just doesn't matter that you have creators who want to work with ByteDance because ByteDance is a foreign corporation with no First Amendment rights. Is that what you're contesting?
So that is what I'm contesting. So you said two things, though, so I could be clear. There's two aspects. Do we have a First Amendment right to work with a foreign company or even a foreign country to publish our speech? And then there's a national security part that you put into that, which goes to the justification.
Forget that.
Forget that, yes. Let's do that.
TikTok came in like a wrecking ball on this.
If that is right, Justice Kagan, then American creators have no right to make documentaries with the BBC. They can't.
This is a good argument. I'm going to back up. This has actually gotten very, very good. G-Mommy said, so basically it's arguing a ban on ByteDance. Yes. It's limiting who they can work with, but this is really interesting because as a content creator, I've worked with British companies. I've been on British TV. So now he's saying, but then can you not do a BBC documentary? That's a really interesting question.
Yeah, but what I'm saying to you is if you just assume a world without TikTok, that where it's only ByteDance, and you were trying to say, well, we really want to work with ByteDance, and Congress was saying, we think ByteDance presents national security interests, and they don't have First Amendment rights. They're just a foreign corporation. I think that in that case, the government, I mean, tell me if you think this is wrong. It just doesn't matter that you have creators who want to work with ByteDance, because ByteDance is a foreign corporation with no First Amendment rights. Is that what you're contesting?
So that is what I'm contesting. So you said two things, though, so I could be clear. There's two aspects. Do we have a First Amendment right to work with a foreign company or even a foreign country to publish our speech? And then there's a national security part that you put into that, which goes to the justification.
Forget that.
Forget that, yes. Let's do that. So if that is right, Justice Kagan, then American creators have no right to make documentaries with the BBC. They can't work with Al Jazeera if Congress wants to prevent that. Any number of other publications that are state-owned wholly or partially. And even under Lamont, remember where you're not even...
They talked about BBC because BBC is state-owned. So they are narrowing in on those examples of, is this a state-owned issue or is this directly an issue with China? And the Congress is saying this is directly an issue with China. So it's interesting to see they're saying, okay, but you're saying then U.S. creators don't have the right to choose who they associate with to publish content.
Creating speech, you're just listening. You know, that was speech from China that the court said you have a First Amendment right to receive.
So would I be right to say that your position is that because of the users who want to associate and want to partner with this foreign corporation, the foreign corporation ends up having, in your view, the exact same First Amendment rights as your users do? In other words, it's irrelevant that the foreign corporation doesn't have First Amendment rights.
I don't think it's irrelevant, because you could imagine a situation where no American distributor or speaker wants to work with that. But let me put it to you this way. The Communist Manifesto written by Karl Marx has no First Amendment standing on its own in America. But if a bookstore wants...
We're back to bookstores. I didn't know we were going to get to the Communist Manifesto. We've gotten some very, very interesting analogies today.
Speaker wants to work with that. But let me put it to you this way. The Communist Manifesto written by Karl Marx has no First Amendment standing on its own in America. But if a bookstore wants to sell that publication, I don't think Congress can prevent it from doing so.
Well, sorry. Go ahead.
No, I'm fine.
No.
I'm good.
Okay. So I want to press you a little bit on the distinction, because in Lamont, the prohibition worked directly on the American. Like, you have to specifically request this information that comes. This is working kind of as Justice Kagan's questions were pressing you. This is working on ByteDance. It's not saying to your creators, you can't post on ByteDance.
And this is that's
indirectly going to happen if
ACB.
ByteDance chooses itself
ACB.
not to permit TikTok to walk away with the code. So does that matter, that distinction between Lamont and this case?
No, for two reasons. One, under the Sorrell case, you look to not just the law itself, but its practical operation. And the practical operation is prevent us from working with ByteDance. So that's one answer. And you bring up Lamont, and Lamont's actually a very important case, I'm sure you all recognize here. It's important to look not just at the court's opinion, but look at the briefing in that case. The government itself never came in and argued there's no right to receive this information. That's the sort of greater argument. All the government argued was, of course Americans have a right to receive this, but it's just not so much of a burden to require them to raise their hand to get it. So Archibald Cox, when he was the Solicitor General, said to the court quite explicitly in the brief, we're not even going to make this argument because we think it's so contrary to history and tradition. All we're going to argue is the burden isn't enough. Now, what happened is the D.C. Circuit kind of turned that upside down and said, oh, Lamont's just a case about the burden. Well, that's because that's the only argument the government was even willing to make in this court.
If you are asking why we are getting into distinguishing between cases, it's because that's what appellate courts do. They don't want to do anything weird. What did we do in this case? What did we do in that case? How does this case inform this case? And judges look back at the history of cases and then reevaluate that. So this is an incredibly unique case. And so when they are analogizing to different cases, there's nothing directly on point, which is why we're seeing so many analogies being brought in.
No argument that Americans didn't have the right to hear that speech.
What about, so I think this goes to Justice Gorsuch's questions about antitrust divestiture. Let's say that for antitrust reasons, or let's even say not for that. Let's say for suspect First Amendment reasons.
Antitrust is
Congress tells Jeff Bezos that he has to divest
Not
in the
back to
Washington
Bezos.
Post. He can no longer own the Post. And let's say that neither Bezos nor the Post challenges that. But let's say that you represent clients who really like the Post as it was, who really want to keep receiving the Post, who really want to publish op-eds in the Post.
Yep.
Would you have standing? Like, what kind of a claim would you be making there?
I believe
There's
so,
the
Justice
standing
Barrett. And
question.
the court has cited Lamont and other cases in more recent years.
For all of you asked, do creators have TikTok? Do creators on TikTok have standing? This is the question of, would readers of the Post have standing if the government said Bezos couldn't own the Post?
To say we've recognized a right of American listeners to receive information from others. And remember, even that is that's only a small part of the argument I'm making on behalf of the creators. I don't mean to diminish Mr. Francisco's arguments on behalf of the company and ByteDance, but the core speech in front of you in this case are the videos and other forms of communication that people like my clients are posting by the millions every day.
Right. His clients like the algorithm. His clients are like, we like this algorithm best. Does the TikTok algorithm for creators operate differently? Yes. Do things go viral differently on TikTok? Yes. Do people gain followers faster on TikTok? Yes. The creators are like, hey, we want to be on this platform. And I saw a great comment in the chat. I don't know if I grabbed it fast enough. There's, over 11,000 of you in here. And I wanted to make sure we could not slow down the chat too much so we could keep a conversation. I'm trying to see if I can find it, but I don't know if I can. But whoever made the comment, thank you. The comment was, readers of the Post might not have standing on this, but people writing the op-eds might. And that's where the creators come in. And I think it's a great point saying who is before the court here. And right now it's the creators, analogizing them more towards writers for the Post, I think is a much better analogy than to readers of the Post. Very, very good point.
On this platform to share with other Americans.
Can you win is it possible for you to win and Mr. Francisco to lose, or you rise or fall together?
No, I think it's possible. I don't think we should.
And this is Justice Barrett asking, can the creators win if the company loses, or do you rise and fall together? That was a big laugh from the audience. I was talking and backing it up.
Other Americans.
Can you win is it possible for you to win and Mr. Francisco to lose, or you rise or fall together?
No, I think it's possible. I don't think we should.
But is it possible for you to win and him to lose?
Let me put it this way. If you were to conclude that something about the corporate ownership structure, and I think there was some conversation about this earlier, impeded Mr. Francisco from being able to assert full-throated First Amendment rights in this case, I would step in and say, well, certainly we can do that and get you to the strict scrutiny. And then the arguments pretty much line up. Then you're in a question of, can the government satisfy strict scrutiny? And I think, Mr. Chief Justice, you asked about, do we have cases for this and that? I think that the idea is, yes, we have cases that say, once you're in strict scrutiny, that regulating the content because you don't think it's going to be pro-American enough, or it's going to be too pro-foreign interest, is just verboten under the First Amendment. That's the history and tradition. And Justice Kavanaugh, when you asked about the broadcast cases, they're grounded not just in scarcity, but they're grounded in scarcity in a particular way. And it has to do with the absolute need Congress has for licensing in a world of scarce resources. And so that's the very small carve-out that even in Turner, the court wouldn't extend to cable television, that exists for broadcast licensing. And if you look on the 200+ years of our country for any other example of foreign ownership of media being regulated by Congress, let alone being permitted in the case law, you are not going to find it. And I think the reason why is because everybody has understood that if you're not in a world of scarcity where licensing is impossible, you cannot give the government, and in this more extreme example, the president himself, unbridled discretion to choose who is a proper owner of a speech platform in this country, because it is so hand in hand with viewpoint. As I said earlier, any number of owners of big media enterprises, whether they be Americans or foreign citizens, could be accused of having a particular viewpoint, but speakers who engage in those platforms have choices they can make. And so, on behalf of our creator clients, we find it
that's an interesting argument.
We find it not at all satisfactory to be told, well, look, just go post somewhere else. It's not enough to tell a writer, well, you can't publish an op-ed in the Wall Street Journal because you can publish it in the New York Times instead. Just like here to say, you can publish it on Instagram or some other platform, not just TikTok. TikTok has a distinct editorial and publicational perspective, and it particularly benefits people like my clients who are not famous people, they're not actors from Hollywood who have a lot of people following them, they're ordinary American citizens whose content that they create on the platform gets privileged by way of the quality of that content. And that's what's so powerful about the platform. So whether you're an ordinary American citizen or, I might add, whether you're a presidential candidate in our last election, if you want to reach new and different audiences, TikTok is the place people go.
This may not make any difference for constitutional purposes, but just out of curiosity, I'd like you to explain what the practical consequences would likely be for your clients if TikTok went dark, as Mr. Francisco
their finger on the algorithm so much. I appreciate that we're getting back to what happens on the 19th when we get to, TikTok's dark day. What happens on the 19th if we get to the 19th and we've done nothing? I'm interested to see how he articulates this from the position of the creators.
I assume there's a great demand for what TikTok provides. And if TikTok was no longer there to provide what your clients really want, is there a reason to doubt that some other social media company would not jump in and take advantage of this very lucrative market?
Their
algorithms aren't the same. Their algorithms aren't the same. You can see TikTok creators with tens of millions of followers who barely get views on a different platform. It's not the same. TikTok, most creators don't have the same following across different platforms. That's more rare, but you will see TikTok creators have a difficult time showing or moving followings to other platforms. And some viewers on TikTok don't want to be on Facebook, don't want to be on Instagram, don't want to be on a Meta property, don't want to be on Snapchat, don't want to be wherever. It's a very different algorithm, and saying, well, you can go post it on YouTube, that's not the same. Having 10 million plus subscribers on TikTok and being told, oh, go start a YouTube channel, it doesn't guarantee that your YouTube channel is going to do well, get views, succeed, break through in the algorithm, and the rest of it. So I'm interested to see how he answers it, but the audiences are also different. I'd be so interested to see, and we don't probably have accurate public breakdowns of what the audience demographic is daily users wise on a Facebook, YouTube, TikTok, but from broad strokes, TikTok is going to skew younger, Facebook skews older. So you also have a very different audience. And for the creator, part of the question is, but where is the audience going to go? And the audience is going to disperse. It's not everybody who leaves TikTok is going to go to Instagram. Some of them are going to go to Snapchat, which I think is still around. So not all of that audience is going to go to one place. And so it also dilutes the audience. And that's different for the TikTok creators as well. So it's not just okay, go put it on Instagram. It's not the same. So it's interesting to see. And TikTok's algorithm shoots things into the stratosphere in such a different way. So, and I'm not surprised primary TikTok creators, do not want that to go away, because if your entire business is TikTok, you might not be getting any monetization on any other platform.
What your clients
So what
really
happens on the
want,
19th?
Is there a reason to doubt that some other social media company would not jump in and take advantage of this very lucrative market?
There are two reasons, Justice Alito. One is many of the declarations from my clients actually explain they've tried on other platforms to generate the kind of audience and engagement they've been able to on TikTok,
Keep reading,
and they've
Emily.
fallen dramatically.
Yeah, I know they haven't so far, and I'm just wondering whether this is like somebody's attachment.
This shit's hard, man. Audiences don't build in long form content the same way. Audience numbers don't build the same way. The numbers on TikTok are wild. It's not the same.
To an old article of clothing. I mean, I really love this old shirt because I've been wearing this old shirt, but I could go out and buy something exactly like that. But no, I like the old shirt. Is that what we have here, or is there some reason to think that only ByteDance has this? The ByteDance has devised this magical algorithm that all of the geniuses at Meta and all of these other social media companies, they couldn't. No matter, they put their minds to it, they couldn't.
I think he just said Meta. I think that the algorithms are different with different companies because they serve different purposes. YouTube, I imagine at this point, has multiple algorithms to do different things because there's so many different types of content on YouTube. Somebody who comes onto YouTube to watch primarily shorts, I don't know who that person is, but maybe there's a person out there to watch primarily YouTube shorts, is not going to be happy if YouTube then serves them any of my videos. They're going to look at it and be like, does that say 7 hours? Fuck yourself. So YouTube's algorithm is trying to facilitate long form live content, long form non-live content, shorts, videos 8 to 10 minutes. They're trying to facilitate a ton of different type of content for different audiences. That algorithm is different. I don't even know what the algorithm at Meta does. It changes all the time. It is serving different kinds of content. Instagram is serving reels vis-a-vis lives, vis-a-vis stories, vis-a-vis posts in your feed. That's different. TikTok does more of one thing. I mean, now it's all TikTok shop, so maybe they fucked their algorithm themselves, but TikTok serves like a thing. It's mostly short form videos. And then if you swipe over to live, then it's live. It's a very different algorithm. It serves a much different purpose and a much narrower purpose. So it's dialed differently than a platform that has so many different kinds of content and so many different types of audiences. The way that my 12-year-old watches YouTube is different than my 16-year-old and then myself. And then Dr. B, who mostly finds his shit on Facebook, say what you will. It's different. When Dr. B's like, how are you watching the news about the California fires? YouTube. He's like, oh, I just went to Facebook. I'm like, of course you did. Of course you did. That's what I get. It's very different. So YouTube's algorithm is serving vastly different audiences vis-a-vis TikTok's algorithm, which is serving, I think, a narrower audience and a much narrower purpose. So I do think it's different. I don't know if that's going to make a difference here, but the algorithms are very, very different.
Come up with this magical thing.
I think empirically, other companies have been trying for a few years to catch up with TikTok and replicate it and have been very unsuccessful. And so that ought to tell you something. And so just imagine the algorithm here as a collection of thousands of editors. You know, imagine the floors of an office building being filled with
They're just dialing down. The algorithm is the editor. Ooh, this is going to be wild for 230 arguments in the future.
Successful. And so that ought to tell you something. And so just imagine the algorithm here as a collection of thousands of editors. You know, imagine the floors of an office building being filled with a collection of editors. You can imagine a situation where that collection of genius that is on a particular floor cannot be replicated by another group of people. And that's kind of what you have here.
All right, I understand that.
Thank you, counsel. Justice Thomas? Anything further, Justice Alito?
Yeah, one other question. I'm intrigued by your Mount Healthy Hunter versus Underwood argument. I mean, maybe you're right, but
they're just taking a fucking wrecking ball to the 230 arguments, but they're saying, look, if other platforms, I think a solid argument, if other platforms could duplicate the TikTok algorithm, would they? I wonder if the government's going to come in and say the reason US-based companies don't duplicate or replicate the TikTok algorithm is because there's shit going on the TikTok algorithm that is anathema to what US-based companies want to do and what their purpose is. So I'm interested to see what the government says to that. But I feel like TikTok right now is Katniss Everdeen going, you know, if we burn, you burn with us. It's like, if we're going down, we're going to just let us just take out the knees of all the 230 arguments in the future. We're just going to lob some grenades into those arguments for now. So interesting to see them taking down that 230 argument in all of their arguments. Both lawyers have done it.
Mount Healthy arose in an entirely different context where you're trying to get to an employer's motivation. Hunter versus Underwood involved an extreme situation where the court looked at the records of a state constitutional convention and came to the conclusion, apparently, that racism was the only motivation for what was done. But it does seem to me to be potentially quite unworkable and contrary to what we've generally said about legislative intent to apply the Mount Healthy framework to a congressional enactment. Do you recognize or do you acknowledge that that would be very difficult? Because when an act of Congress is passed, there could be more than 250 different motivations for the votes that were cast by the members.
Yeah, I totally understand that. And in Hunter, the court actually engaged with that problem to some degree. And what Hunter said is, to avoid that problem, we're going to look just at two things. One is the state's brief, which I'd say is the Solicitor General's brief by comparison here, and the text of the law. And here, that's the only thing I need to rely on to get you to the place that they wouldn't have announced.
Well, it gets you to the place that this was part of what motivated Congress. But why does it get you home? Well, particularly when there's a severability clause in this act.
It can't be only part of it. It has to be enough to sustain the entire act, or at least the parts that you wouldn't sever from the act. And so I think the reason why is because it's not just the content recommendation algorithm part that can be theoretically, I guess, severed out. It's also the covered company provisions, and it's just the whole approach of the statute that is based on content, not on data security.
Right, and that's what they're saying.
Justice Sotomayor?
No, I'll save it for the SG.
Justice Gorsuch? Justice Kavanaugh?
I think they're good.
One quick question. You repeatedly say that from your perspective, the government's motivation is that the content might be too anti-American or too pro-China, et cetera. So that's why you think this is a content-based restriction. But I guess I'm curious if you would say the same thing if the government had articulated its rationale as saying, you know, our motivation is to limit foreign interference in American social media platforms or discourse. Isn't that a different motivation from the standpoint of how we characterize this?
I agree, but then the question I would ask if the government said that, which I think kind of in the reply brief, maybe the government does say that, is that how on earth are you then serving a national security interest? You know, if all you're doing is just saying, we don't like a foreign country rearranging cat and dance videos, like it's hard to come in and make a national security argument. So the only way you get to national security, which is the government's own argument, is to look at the substance that's being rearranged and say, we don't like the way the substance is going to be rearranged and curated differently.
Thank you.
Thank you, counsel.
Okay, we're going to get to the government argument. So we're going to get to the Solicitor General. This
General
is going to
be
Mr. Chief.
The Solicitor General is going to argue on behalf of the government. Remember, we are watching Supreme Court arguments regarding the law that was passed by Congress that is being called the TikTok ban. The law requires that either TikTok divest its ownership and association with ByteDance, or they can no longer be hosted in the U.S. App Store. They shouldn't be hosted on U.S. servers, etc. TikTok has said this means either we have to sell or we have to go dark. That's the only option. The justices have pointed out other options. Couldn't you get a new algorithm? Couldn't you do this? Couldn't you do that? TikTok has said, essentially, we're not doing any of that. The only option here is divest or die. The justices are saying, you have other options, you just don't like them. So that's on you. We are now going to get to the government's arguments. We have heard from TikTok through their lawyers. We have heard from the creators that have sued through their lawyers. And now we are going to hear from the government that's going to respond to both, because the arguments, though slightly different, are similar. They are close enough. But you had asked who the creators are that are named in the suit. And let me see if I can pull up the heading on that before we go any further, because I think that will help. There are a million amicus briefs here. So let me try to pull up the list of all of the named plaintiffs in the creator suit real quick because I thought I had it. And then I realized that I did not. So where are they? Give me just 2 moments. You know what? I'm going to try to pull this up one more time differently, and then we'll just move on, listen to what the solicitor has to say, and then go from there. There are so many amicus briefs that it buries some of the briefs that I'm looking for. So let's keep going on this, and then I will give you the name of the TikTokers that are suing, and I will link that down below. If you guys want to read all the briefing on this, I'll link it.
Justice, and may it please the court.
So this is the
Chinese
Solicitor
government's
General.
control of TikTok poses a grave threat to national security. No one disputes that the PRC seeks to undermine U.S. interests by amassing vast quantities of sensitive data about Americans and by engaging in covert influence operations. And no one disputes that the PRC pursues those goals by compelling companies like ByteDance to secretly turn over data and carry out PRC directives. Those realities mean that the Chinese government could weaponize TikTok at any time to harm the United States. TikTok collects unprecedented amounts of personal data, and as Justice Sotomayor noted, it's not just about the 170 million American users.
Smart to directly pull out what the justices have said earlier in the arguments. Smart.
But also about their non-user contacts who might not even be engaging with the platform. That data would be incredibly valuable to the PRC. For years, the Chinese government has sought to build detailed profiles about Americans, where we live and work, who our friends and coworkers are, what our interests are, and what our vices are. TikTok's immense data set would give the PRC a powerful tool for harassment, recruitment, and espionage. On top of that, the Chinese government's control over TikTok gives it a potent weapon for covert influence operations. And my friends are wrong to suggest that Congress was seeking to suppress specific types of content or specific types of viewpoints. Instead, the national security harm arises from the very fact of a foreign adversary's capacity to secretly manipulate the platform to advance its geopolitical goals in whatever form that kind of covert operation might take. The Act addresses the threat of foreign adversary control with laser-like focus. It requires only divestiture of TikTok to prevent Chinese government control. And that divestiture remedy follows a long tradition of barring foreign control of U.S. communications channels and other critical infrastructure. So no matter what level of First Amendment scrutiny applies, this act is valid because it's narrowly tailored to address compelling national security threats. Now, my friend Mr. Fisher just emphasized, and I acknowledge, that millions of Americans enjoy expressing themselves on this platform. But the important thing to recognize is that the act leaves all of that speech unrestricted once TikTok is freed from foreign adversary control. The First Amendment does not bar Congress from taking that critical and targeted step to protect our nation's security. I welcome the court's questions.
Is there any difference between content manipulation by a non-U.S. company as opposed to a U.S. company? I didn't hear Mr. Fisher make a distinction
between
the two.
Good question.
Yes, and I think the important thing to recognize is that the act here is targeting covert content manipulation by a foreign adversary nation. Now, I understand my friends to say—
What difference does that make?
The difference is that there is no protected First Amendment right for a foreign adversary to exploit its control over its speech platform.
The difference between covert and non-covert.
So I think that Congress's concern with the covert operation was that a foreign adversary could effectively weaponize this platform behind the scenes in order to achieve any number of geopolitical goals. Here are some of the examples that come to mind. One of the pages out of the playbook here is for a foreign adversary to simply try to get Americans arguing with one another to create chaos and distraction in order to weaken the United States as a general matter and distract from any activities that the foreign adversary might want to conduct on the world stage.
What do you mean by covert, though? I mean, does covert just mean it's hard to figure out how the algorithm works? Because we could say that about every algorithm.
No, the covert nature of it comes from the fact that it's not apparent that the PRC is the one behind the scenes pulling the strings here and deciding exactly what content.
And that's why both of the other attorneys said if it's not apparent who's pulling the strings, wouldn't a registration or a disclaimer be the appropriate remedy? Both lawyers brought it up.
is going to be made to appear on the site. And another way that the
It's just because we don't know that China's behind it? That's what covert means?
Well, I think
it doesn't have anything to do with the difficulty of figuring out what the algorithm is doing. It's just because people don't know that China is pulling the strings. That's what covert means?
What it means is that Americans are on this platform thinking that they are speaking to one another, and this recommendation engine that is apparently so valuable is organically directing their speech to each other. And what is covert is that the PRC, a foreign adversary nation, is instead exploiting a vulnerability in the system.
Well, if that's all it means, that like people don't know that China's behind it, like everybody now knows that China is behind it.
No, but it's the specific content that's being manipulated would be unapparent. And so I think
that's true of every search engine. I mean, you can.
It's not just true of every search engine. We're covering like a trilogy of lawsuits that say that our media articles are also manipulated by PR representatives. So at this point, what is not manipulated is the question.
Take any of these algorithms, whether it's X or whether it's, you name it. What are the new ones? Blue Sky? I mean, none of these.
What are the new
none
ones?
of these are apparent, right? You get what you get, and you think that's puzzling. And
well, maybe you do.
And it's all a little bit of a black box. So you can't just mean it's a black box.
You get what you get, and you don't get upset.
They're all black boxes. And if you just mean what's covert is the fact that there's China behind it, I mean, honestly, really, like everybody does know now that there's China behind it. So I just don't get what this covert word does for you.
I think the problem with just saying as a general matter, China has this capability and might at some point be able to exercise it and manipulate the platform is it doesn't put anyone on notice of when that influence operation is actually happening. And therefore, it doesn't guard against.
Are you going to put everyone on notice when there's an influence operation happening by PR companies? Isn't that the lawsuit that we're following with Blake Lively? Is that there was an influence operation happening? Or is anyone on notice to that? Like, when are we going to all be on notice of everything? How much disclosure? I'm like, all disclosure. Bring all the disclosure. Fine. Make every single news program disclose how much money they get from whoever their sponsors are. Make everybody disclose everything then. If that was the case, wouldn't you just tackle making everyone disclose the influence on everything? Maybe we just end up, and this is me being hyperbolic, maybe we just end up in idiocracy in the court scene where the lawyers come in with the sponsorships like they're race car drivers. Maybe we just make Congress wear jerseys with their sponsors printed on them. Maybe we just do it that way, like sponsored by, and just put all of their donors on a jersey. So when they walk into Congress, they just have to wear a jersey like they are a F1 racer. Maybe we just do that. Okay, continue to tell us about covert.
Against the national security harm from the operation itself.
Isn't that a pretty paternalistic point of view? I mean, don't we normally assume
yes, it is a paternalistic
that the best remedy for problematic speech is counter speech? And TikTok says it could even live with a disclaimer on its website saying this can be covertly manipulated by China.
That's what the other...
in case anybody were left in doubt after today
said
about that possibility. So you're saying that won't work because?
That won't work because it is such a generic, generalized disclosure that it wouldn't put anyone reasonably on notice about when it's actually happening. And the example I've been thinking about is...
Your best argument is that the average American won't be able to figure out that the cat feed he's getting.
Is your best argument that Americans don't understand? Is that really what you're going with? And she's like,
getting on TikTok could be manipulated, even though there's a disclosure saying.
I'm going to interrupt one more time, and I'm going to back up and let him ask his whole question. I think where the government has put themselves at a disadvantage in arguing here is there are things that they submitted to the court secretly that they don't want to say because we don't have security clearance. And so they're trying to argue around the other information that they want to say, but can't because some of that they don't want to disclose. So we're now in this catch-22 of, okay, then you're saying that just putting a disclaimer on it's not enough because Americans won't really understand. So make it more transparent. How do you make them understand.
On notice about when it's actually happening. And the example I've been thinking about is...
argument is that the average American won't be able to figure out that the cat feed he's getting on TikTok could be manipulated, even though there's a disclosure saying it could be manipulated.
But imagine if you walked into a store and it had a sign that said, one of 1 million products in this store causes cancer. That is not going to put you on notice about what product is actually jeopardizing.
I mean, California just says everything causes cancer. It's gone like Prop 65. It's just gone the other way. Like everything has a label slapped on it saying this could cause cancer. And then it also kind of reduces the impact of those Prop 65 warnings. So, okay.
Your health. And I think that's roughly equivalent to the type of disclosure they're contemplating here. They brought up the example of the Foreign Agents Registration Act, FARA. There you have to disclose the actual content.
If that's true, then wouldn't that be true for all social media companies, for all content? I mean, every editor,
this is what y'all were asking earlier,
in its editorial room makes decisions about what it's going to run and how it's going to say it.
So shouldn't they disclose why?
Has preferences, whether it's domestic or foreign. And nobody really knows exactly when those editorial decisions are being made or how, but they're generally aware, and we think that's enough.
I think, though, that there is a real risk that when a foreign adversary has control of that kind of mechanism and a speech platform in the United States, it could weaponize that platform to harm United States interests. And one of the key ways that the PRC flexes this muscle is to suppress speech.
General, I'm sorry to interrupt you, but we're not arguing about the compelling interest. We're arguing about the tailoring.
Right.
Right. And so I guess what I would say, you began by saying the cure for concerning speech is counter speech. Here, I dispute the premise that Congress was specifically concerned about any particular subject or any particular viewpoint. It wanted to close off a capability of a foreign government. But in any event, it's very hard to engage in counter speech when you don't know because someone is secretly manipulating the platform behind the scenes. And in particular, what the PRC has the capability to do is simply silence American voices.
With a newspaper owned by a foreign company and a foreign government, you wouldn't know when it's exercising editorial discretion about this article or that article or how it's doing it. So maybe we just need to shut down the Oxford University Press in America, or
that was a very strange emphasis on
foreign-owned
press.
Politico, I was told today, is owned by Germany.
So
that would all be okay on your theory,
that.
so long as Congress designates that country a foreign adversary?
We are not asking the court to articulate bright-line rules to govern all kinds of hypothetical situations.
I am testing your argument.
Yes, and what I want to acknowledge is that sometimes the court has...
Ma'am, they want to know if the government's overreaching or not. That's what they're getting at, which is why the questions are fast, furious, and pointed. They want to know, is the government overreaching here? And can the government then just shut down anything? So let's go.
Recognized that a speaker-based preference might reflect a content-based preference. And in the context of ownership of a newspaper, for example, in part because a newspaper is a one-way channel of communication and is generally understood to represent to some extent its publisher's views, maybe the court would more readily infer that a regulation targeting that is actually aiming to target content. But I don't think the court could draw the same conclusion here.
I'm not talking about the compelling interest or any of that. I'm talking about the tailoring. And
she keeps
you're saying
back.
We have no alternative but to stop this speech altogether. We can't rely on disclosure. But you say that wouldn't...
Remember that the justices are at this point questioning about strict scrutiny. If this law is going to be determined constitutional or unconstitutional, you need to take a look, and they are arguing at the strict scrutiny level because that is the highest level. So they're kind of in that arguendo, but strict scrutiny. Compelling government interest, they've already kind of conceded that if this is about data, then yes, there's a compelling government interest. Then we get to the narrowly tailored to achieve that interest, and then we get to least restrictive means. He's trying to get to the narrowly tailored. She keeps defaulting back to, but it's a compelling government interest. He's like, blah, blah, blah. We've gotten there, blah, blah, blah. We need to get to, is this narrowly tailored, or is this overreaching?
Apply to Politico or to the Oxford University Press because
In the circumstance where you have a newspaper that is understood to reflect its publisher's views, then you might think that disclosure would be a more adequate remedy there because it's not just holding itself out as a forum for speech between other people. I think social media platforms do raise distinct interests in this regard because what people think when they're engaging with TikTok is that it's organically feeding them videos based on the recommendation engine. And if actually China is behind the scenes engaging in this kind of covert operation, it does present a distinct national security risk. Of course, the other big difference with the newspaper is it's not likely to be collecting sensitive personal information about 170 million plus people and then having the capacity to send that back to a foreign adversary.
General Prelogar, can I, oh, go ahead.
I was just going to say, did I understand you to say a few minutes ago that one problem that ByteDance might be through TikTok trying to get Americans to argue with each other?
Yes, it's ByteDance. Yeah, is it ByteDance? Yes, it's What? Did I hear you correctly? ByteDance? What?
That it might be just trying to foment
if they do, I say they're winning.
Or dissent.
I need to back up. Are you trying to just get Americans to argue with each other?
About 170 million plus people and then having the capacity to send that back to a foreign adversary.
General Prelogar, can I, oh, go ahead.
I was just going to say, did I understand you to say a few minutes ago that one problem that ByteDance might be through TikTok trying to get Americans to argue with each other?
That it might be just trying to foment
if they do, I say they're winning.
Or dissent. That might very well be true, Mr. Chief Justice. And I think the point I'm trying to make is that China is a foreign adversary nation.
He said if they are just trying to get Americans to argue with each other, they're winning. I mean, is that the only platform, Justice, that people argue with each other? I would say no.
It looks for every opportunity it has to weaken the United States and to try to threaten our national security. And if it has control over this key communications channel, it's hard to predict ex ante exactly how it's going to use that as a tool to harm our interests. But we know it's going to try, first and foremost, by seeking to get the data of these American users, which would be of a piece of all of the activity the PRC has already undertaken to breach our laws, hack OPM, for example, and exfiltrate the background files and security clearances of 20 million government employees, the breach of Equifax to get sensitive financial data, Anthem to get sensitive healthcare data. We know that the PRC has a voracious appetite to get its hands on as much information about Americans as possible, and that creates a potent weapon here because the PRC could command that ByteDance comply with any request it gives to obtain that data that's in the hands of the U.S. subsidiary.
Thank you.
General Prelogar.
Suppose that TikTok had no connection whatsoever with any foreign government. It was owned instead by an immensely rich multinational corporation, and Congress
this is going to be separating out, I think, the algorithm and the ownership.
Corporation really has it in for the United States and is going to use this extremely popular platform to do everything it can to undermine the United States in all the ways in which you think that TikTok may pursue at the direction of the PRC. Would that be the same case?
I think there would be a first-order question of whether the multinational corporation itself has First Amendment rights.
All right, it's an American corporation.
So if it were an American corporation, I think that, and Congress disagreed with the viewpoints or content the corporation would display, harder. Obviously that's a direct regulation of protected speech and it would trigger strict scrutiny. I think that's different in kind from what Congress was worried about here, which was not regulating speech as such, but instead regulating foreign adversary control.
And so your argument depends on the fact that what is at bottom here is the People's Republic.
I tried to move the closed captioning and it just froze.
That's what your argument depends on. If this were an American corporation, it'd be an entirely different thing.
Exactly. And the reason we know the statute is different is because all of the same speech that's happening on TikTok could happen post-divestiture. The Act doesn't regulate that at all. So it's not saying you can't have pro-China speech, you can't have anti-American speech. It's not regulating the algorithm. TikTok, if it were able to do so, could use precisely the same algorithm to display the same content by the same users. All the Act is doing is trying to surgically remove the ability of a foreign adversary nation to get our data and to be able to exercise control over the platform.
I'm sorry.
surgically goes to narrowly tailored.
I just wanted to respond to Mr. Fisher's argument about the rights of Americans to receive information, say, from the PRC or anyone else, and that even if ByteDance did not itself have First Amendment rights, that Americans would have a First Amendment right to receive that information in the Lamont sense.
Yes. So I think that Lamont reflected a principle that there can be a right of
I think the argument's going to be they'll still receive that information. It's about who owns it.
American listeners to receive information.
Squirrel. For those of you asking about the mug, I have a similar mug, not this color, listed in my Amazon shop. Amazon will take your data, but it is a giant Stanley mug. This was a collab with Starbucks because I like the color, but Stanley makes these. And you can get them from Stanley. But it's basically a coffee pot of coffee.
And if Congress is directly regulating that based on disagreement with the speech that's being sent into this country, that's obviously going to trigger heightened scrutiny under the First Amendment. But here, I think the users have to be asserting a different type of interest, because what Congress was safeguarding against was not the ability of TikTok to continue to operate or the users to post content. It was focused only on foreign adversary control. And so the users would have to demonstrate that they have some unqualified First Amendment right to post on a platform that's controlled by a foreign adversary, which could use that access to then threaten our nation's security by gathering data on tens or hundreds of millions of Americans, and also use it for covert influence operations of whatever form. And I don't think there's a First Amendment right to do that.
I was trying to think of whether there's a historical analog here, and this is what I came up with, and you can tell me whether it's fallacious. In the mid-20th century, we were very concerned about the Soviet Union and what the Soviet Union was doing in this country. And the Communist Party of the United States at that time was integrally attached to the Communist International, which was essentially a Soviet operation, right? So if Congress had said, oh, it's very nice, we can have the Communist Party USA, but it has to divest, it has to completely divorce itself from the Comintern and from any international ties that it has, do you think that that would have been absolutely fine? And so if the answer is yes, it would have been fine, it's just like this case, or if the answer is no, why is it not like this case?
So I guess I think I would need to know more information about how the international organization is able to exercise control.
When I can't answer a question, I think I need more information. How do you feel about this? I feel like I need more information. What about this? I'm going to need more information. So we've gone all the way around the horn on the arguments today. Interesting when we've gotten back. Mama Bear in the chat said, "Oh, McCarthyism, didn't have that on my bingo card." Yep, all the way around the horn.
Over the American affiliate. And if it had the capacity, for example, to, in an unqualified fashion, gather data from that affiliate in a way that was going to jeopardize our nation's security.
Well, I'm talking more about sort of the content. Let's put the data collection piece of this aside, which seems not very pertinent to my 1950s analog. But, very concerned about the kind of speech that the Communist Party was making in the United States. And it turns out that that content was pretty well scripted someplace else.
I think if it was specifically a concern about the content, then that would trigger heightened scrutiny under the First Amendment. We're not trying to run away from that principle here. Instead, we're making, I think, a narrower argument.
Well, then I think that you're I think you've just given your thing away, because content manipulation is a content-based rationale. We think that this foreign government is going to manipulate content in a way that will that concerns us and may very well affect our national security interests. Well, that's exactly what they thought about Communist Party speech in the 1950s, which was being scripted in large part by international organizations or directly by the Soviet Union.
I disagree that the concern with covert content manipulation is itself content-based, or that it looks anything like the kinds of laws this court has previously said are content-based. The court most recently in City of Austin said you only have a content-based law when Congress is setting out to discriminate against particular subject matters or particular viewpoints. So it's not enough that the law is regulating in the space that involves content in some way. You have to have this motive by Congress to actually want to suppress speech on certain topics or certain viewpoints viewpoints. Here, Congress just wants to cut the PRC out of the equation altogether, and all of the same speech could continue to happen on the platform. It's like patching up a backdoor vulnerability that the PRC has that we can't totally see around all the corners to imagine how it could use it against our interests, but we know the PRC will do whatever it can to try. And I think that is different in kind from imputing to Congress some motive to specifically get more speech on certain topics or with certain viewpoints. This law was passed by broad bipartisan majorities in both houses of Congress, and our legislators and our legislators don't always agree on everything. I think it's unlikely that all of them had exactly the same views about what's good content on TikTok or what are good viewpoints. They weren't united on that. What they were united around was the idea that it is a grave threat to our nation if the PRC can itself behind the scenes be controlling how this.
Her argument right now has gotten to, Your Honors, wise justices. Our Congress agrees on nothing, but they did agree on this. Shh. They agreed. They all agreed. Shh. Just shh. Let them work.
Platform operates.
That's the argument at the moment.
Why doesn't this act classify on the basis of speaker?
I do think that when it comes to the PRC and ByteDance, you could treat this as a speaker-based restriction.
And aren't
they have no rights,
speaker-based restrictions almost always viewpoint-based restrictions, content-based restrictions?
She's going to say
the court has said
they
it
don't have
depends.
rights.
It hasn't applied an inflexible rule that any time you are regulating certain speakers, you are invariably regulating based on content. Instead, the court has said it warrants closer consideration. And here, if you look at the U.S. speakers, TikTok U.S. and the users, none of them are being regulated in a way that suggests it's disagreement with their content. It's all about what our foreign adversary is doing.
It's hard for me to think of situations, maybe they exist, where our classification based on speaker is not viewpoint or content-based restrictions. I mean, somebody says, Joe can't talk anymore. We're going to shut Joe up. And we don't know what he's going to say tomorrow or 2 weeks from now.
Excuse me, Justice, would you like to come to my comment section Come to my comment section. I'm teasing, but occasionally it's, you talk so much. Yes. However, that is not the government. I think this is Kavanaugh speaking. Let's continue.
What he's going to discuss,
but Joe can't
whatever
speak
he
anymore.
says is bad because Joe is a bad person. I mean, that's
generally bad guy rule.
Content-based, isn't it?
I think when it comes to a foreign adversary, it's not right to view it that way. And the reason for that, again, is this is a sophisticated adversary nation, and we can't just simplistically say, oh, what the PRC is going to want is to see more pro-China content on this app. As Chief Judge Srinivasan observed, there are various ways that the PRC could try to create some kind of false flag operation and actually promote anti-China content, not to dictate how Americans should think about things, but simply to create some trumped-up justification for a military or economic action that the foreign adversary wants to take against us. And I don't think a concern with trying to ward off that capability.
Why isn't that viewpoint or content still? We don't know what the content's going to be, but we know it, Joe, is bad.
Because I think the better classification is to recognize that what we're trying to prevent is not the specific subject matter, the specific viewpoints, but the technical capability of a foreign adversary nation to use a communications channel against this.
I guess I'm just struggling how covert content manipulation isn't content-based restriction.
So again,
it's kind of hard to avoid the word content, and it's kind of hard to avoid the word viewpoint here, isn't it?
I don't dispute that it's related to content, but I don't think it reflects Congress seeking to set out in advance what kind of speech we should have reflecting certain views on certain topics. Instead, it's about trying to close off a vulnerability that our foreign adversary nation could exploit. And I would be remiss if I didn't point out that even if you thought this was content-based, all that means is that we're in strict scrutiny, and as the D.C. Circuit recognized here, we think that this law serves compelling national security concerns that sound in some of the same arguments I'm making here, and that have a long-standing correspondence to history and tradition of trying to prevent foreign control.
And then we get to the question whether there's a less restrictive means. I get that, and whether disclosure might suffice. On the data security point, your friends on the other side make the argument that if that were the concern,
I know you've got friends on the other side
Congress could ban TikTok US from sharing data with anyone, and on pains of penalties that would put people in prison and shut the company down.
I'm actually surprised they didn't keep going with the Jeff Bezos analogy on Jeff can't speak.
Why isn't that a less restrictive means available?
So I was surprised to hear petitioner offer that up today because there was a long course of discussion between the executive branch and ByteDance and TikTok leading up to Congress's enactment of this act that spanned over 4 years, an extensive conversation about what limitations could be placed to protect Americans' data. And it was never a suggestion that there would be any way to create a true firewall that would prevent the U.S. subsidiary from sharing data with the corporate parent. And the reason for that sounds in the technological features of this application. I think there can be no reasonable dispute that the source code development and the maintenance of this algorithm rests in China, which is why China has sought to try to control
and
export restrictions with respect to the algorithm. And what that means is you need substantial data flows between the companies in order to continue to modify that algorithm, refine it, and so forth. So I don't think that that was an option ever on the table, including with respect to the proposed national security agreement that was insufficient in protecting our data privacy and security concerns.
That didn't come across enough in the briefs. If we are in the world of data protection as opposed to content control, I think it's hard to get around the post-divestiture provision that says you can't do business with them on the algorithm, because that very much is content-based. It's a content-based restriction. But what you're saying is you can't do it for a data control reason, meaning that you can't really run their algorithm without sharing the very data that we are concerned about as a threat, correct?
That's right, Justice Sotomayor, and you don't have to take my word for it. You can look at the specific terms of the National Security Agreement that ByteDance itself proposed.
But also, that's what the lawyers for TikTok said. The lawyer for TikTok said, we are not separating out TikTok from the algorithm with ByteDance. So even if we sell it, we're not going to stop sending information back and forth to the algorithm, and we're not going to divest from the algorithm. This really isn't about ownership. This argument at the heart is really about the algorithm. And the company's like, we're not going to separate from that algorithm. That algorithm is not going to be open source. That algorithm is not going to be exported out of China. That algorithm is not going to be shared. And so they've said, as a company, it's us in this algorithm or nothing. And so that's what they're getting to now.
The relevant definition of the accepted data is at JA 239 to 240, and it references categories of information that would, of necessity, technological necessity and business necessity, have to flow back to China. And the relevant categories are in the sealed appendix, but I would really encourage the court to look this up because it's eye-opening. It is at the Court of Appeals sealed appendix 249
well, don't
to 250.
seal it. I want to know. This is exactly what I want to know. I want the sealed appendix. And the sealed appendix, she is saying, lines out for the court only all the information that would necessarily have to be exported to make the application still work. Isn't that what we want to know? That's what we want to know. But also, that's probably not a national security issue. I wonder how much of that is also a proprietary issue. I'm just curious.
52 and 254. If you look at that information, it was a wealth of data about Americans that was going to have to go back to China in order for the platform to just continue its basic operations. And there's a legitimate commercial justification for that, but it creates this gaping vulnerability in the system because once that data is in China, the PRC can demand that ByteDance turn it over and keep that assistance secret. And the one final point on this is that ByteDance was not a trusted partner here. It wasn't a company that the United States could simply expect to comply with any requirements in good faith, and there was actual factual evidence to show that even during a period of time when the company was representing that it had walled off the U.S. data and it was protected, there was a well-publicized incident where ByteDance in China surveilled U.S. journalists using their location data, this is the protected U.S. data, in order to try to figure out who was leaking.
So she's saying right now that even if there's a firewall between the servers in Virginia and everywhere else, that it can still be forced to share this information because the information necessarily has to flow back to wherever the algorithm is to continue the algorithm working. Lori and CT said, I never export my contacts. It's their decision. True, though there are some pretty notable lawsuits that indicated that when you sign up for TikTok, even if you said, do not share my contacts, it took that information anyway. There were numerous lawsuits over it because even if you said, do not share contacts, TikTok took that information anyway. They said cute and then did it. So there are, some of those choices are also not choices. It's interesting to hear how much information that they are saying is exported anyway. I'm very curious to hear about the surveillance of journalists. So let's see.
Here, it wasn't a company that the United States could simply expect to comply with any requirements in good faith. And there was actual factual evidence to show that even during a period of time when the company was representing that it had walled off the U.S. data and it was protected, there was a well-publicized incident where ByteDance in China surveilled U.S. journalists using their location data. This is the protected U.S. data in order to try to figure out who was leaking information from the company to those journalists.
General, you want us to look at that. And you get to look at it.
This is going to be
your friends on the other side don't get to look at it. That doesn't seem fair.
I've got friends on the other side. So this is the information that is sealed. The court has it. The government has it. The attorneys for TikTok and the attorneys for the creators don't have it. And we as a public don't have it. We're getting back to the secret evidence. And so Gorsha is just like, how is it fair that you are providing information showing that the PRC has demanded that ByteDance disclose information to them to surveil journalists? But how is it right that you're making legal arguments based on information that the other party doesn't have?
The sealed appendix, Mr. Chief Justice, so it's their information. They can look at it. It's just under seal to protect their proprietary business information.
General, so
well, that's different.
Go back to
if it's TikTok has this information because it's proprietary business information, then that's fair.
But your friends on the other side don't get to look at it. That doesn't seem fair.
That's the sealed appendix, Mr. Chief Justice, so it's their information. They can look at it. It's just under seal to protect their proprietary business information.
So that's their
General,
sealed appendix.
So I want to go back to the discussion about content discrimination, and we're going to shut Joe up. Here, it seems to me like we are saying to ByteDance, we want to shut you up. And so let's say that I think that that is content discrimination based on speaker. Tell me if I think that, tell me if I have to conclude that it is also speaker-based discrimination and content-based discrimination for TikTok.
No, it is not. And the reason for that is because it would be an anomalous principle to say that an entity outside the United States that can't assert its own First Amendment rights can somehow manufacture that right through the expediency of forming a U.S. subsidiary, especially one that it wholly controls.
So you don't have to stand on that argument that you were having with Justice Alito and Justice Gorsuch to still have your point about content discrimination.
That's right. And I think if you're focusing in on the relevant U.S. entities here, TikTok U.S. and the users themselves, this act isn't regulating them in any way. It's not trying to dictate the algorithm that TikTok U.S. can use. And in fact, Congress, I think, was doing everything it could to preserve access to TikTok in the United States in recognition that Americans enjoy expressing themselves and building community on the site.
Well, one last quick question. Sorry, just one last quick question. Justice Gorsuch had asked your friends on the other side whether the new administration on January 20th could extend the deadline. What's your position on that?
So I think it tees up a statutory interpretation question of whether there can be an extension after the time period for divestiture has lapsed. I would think the court might start with its decision in the Hawley Frontier case, which did recognize the ability to get an extension after a lapse like that.
So it's your position that they could?
We have not run it to ground, in part because it's simply not presented here, and I'm not prepared to take a position on that statutory interpretation question.
Yes, no.
I do want to emphasize, though, that my friends have pointed to January 19th, or 9 days from now, as a moment when TikTok might go dark. At the outset, of course, Congress was hoping to prompt a divestiture, but I think the more important thing to focus on now is that even if that were to happen, Congress specifically anticipated it and provided authority to lift these restrictions as soon as there's a qualified divestiture. And the reason for that is because foreign adversaries do not willingly give up their control over this mass communications channel in the United States. And I think Congress expected we might see something like a game of chicken. ByteDance saying, we can't do it, China will never let us do it. But when push comes to shove and these restrictions take effect, I think it will fundamentally change the landscape with respect to what ByteDance is willing to consider. And it might be just the jolt that Congress expected the company would need to actually move.
We've reached the fuck around and find out argument. Your Honor, they're saying, Justice, they're saying it's impossible. They're saying China refuses to allow this to happen and has the power to say to ByteDance as a company, no, you cannot. They're saying, so if we're playing a game of chicken, then you need to let the law go into effect and see if it changes the landscape.
Forward with the divestiture process. So it's not irrevocable.
That's an interesting point, and I hope Mr. Francisco or Mr. Fisher, whoever's delivering the rebuttal, will address it. So if we were to affirm and TikTok were forced to cease operations on January 19th, you say that there could be divestiture after that point and TikTok could again begin to operate the way
she said there was a mechanism for it almost immediately.
That's exactly right. There's nothing permanent or irrevocable that happens on January 19th. And I think that Congress might have thought that we get in a situation here where a foreign adversary is doing whatever it can to just not comply. It's hoping the United States is going to blink first through our court system or through the executive branch getting cold feet about enforcing the law. But Congress set a deadline, and I think it thought that deadline would have a forcing function.
Well, let me ask you a question about your effort to draw a distinction between ByteDance's speech and TikTok's speech. So suppose that the People's Republic of China funds a movie, and there is an entity in the United States, a U.S. corporation, that thinks, wow, this is a great movie. And while the PRC would not have a First Amendment right to show it in the United States, would you say that the American company would not have a First Amendment right to do that because whatever expression there is in that movie, it's the PRC's expression, it's not their expression?
No, I wouldn't make that argument. And I want to be really careful.
I thought that was the argument that was being made, no?
No. So our argument is that this is not a direct regulation of protected speech in the first place, or at most it would warrant intermediate scrutiny because of the indirect effects that it might have on the American users or on the U.S. subsidiary. We're not suggesting that if Congress sought to directly regulate and prohibit speech in the United States based on concerns about its content or viewpoint, that's somehow immune from First Amendment scrutiny just because it comes from a foreign source. Obviously, that kind of law is going to trigger strict scrutiny. And I imagine it would be a different constitutional analysis because it's hard to imagine the same profound national security harms that would exist in that scenario as compared to what we have here.
Thank you.
I think the
wasn't the whole point
game of chicken analogy is actually
requirement
pretty decent.
That the content on TikTok would be different if it was owned by a different company. I'm still struggling with your insistence that this is content neutral versus content based when we have that kind of circumstance.
The reason that I am continuing to try to hold the line on that is because there is nothing in the Act that would directly dictate any different mix of content on TikTok. The U.S. subsidiary could use the same algorithm, show the same content by the same users in exactly the same order. It's not about trying to interfere with the U.S. subsidiary's exercise of editorial judgment in any relevant sense. Instead, all Congress was doing was homing in on the problems of having a foreign adversary be able to interject itself and be able to harvest the data.
But your friends on the other side say that the motivation for doing that is because the foreign adversary might influence or change the content. So content
they were talking about data with that.
Content matters, doesn't it?
I think that content was relevant to Congress's concern about an adversary having control over the communications channel. I think not, again, because of any particular concern about viewpoints or subjects, but just that this would be
isn't that relevance enough to trigger at least some scrutiny, with a heightened scrutiny from the standpoint of our legal tests?
I certainly understand that intuition, and if the court thought that it were prudent to simply try to rule narrowly here and not dictate broader First Amendment principles, we have no problem with the court assuming that heightened scrutiny applies. We think the law easily satisfies it. We do think that intermediate scrutiny is a more appropriate framework for this kind of law that's not directly targeting protected speech. But in any event, there's a compelling national security interest here, and the law isn't just narrowly tailored, it's precisely tailored. It's trying to fix the thing that's creating the problem, which is the PRC's involvement and the Chinese government's ability to exercise this control over the corporate entities.
How are we supposed to think about the two different rationales here and how they interact? The data collection rationale, which seems to me at least very strong, the covert content manipulation rationale, as the hypotheticals have illustrated, raise much more challenging questions for you about how far that goes. And if that alone, if you didn't have the data collection piece, you only had the covert content manipulation piece, and then Mr. Fisher's point, Mr. Francisco's, that Congress would not have enacted this just based on the data collection rationale alone. Just your understanding of how the two arguments fit together.
Sure, and let me walk through our defense of the data protection rationale and why we think it's a full justification for this law, and the court could stop there and then be responsive to their arguments that somehow the interest in preventing covert manipulation somehow taints it. So just on data protection, I think that it should be beyond dispute that, of course, our nation has an enormous interest in keeping the sensitive data out of the hands of our foreign adversary, and it should also be beyond dispute that our foreign adversary has an existing capability through its laws and through the way that these companies are integrated to get its hands on that data. There is no question that Congress was sincerely motivated by that concern. There's a whole lead up to the statute here where the executive branch across two different presidential administrations was expressing concerns about the data problems. Congress was extensively briefed on those problems. It passed a companion data protection statute at the same time that was intended to prevent selling data to foreign adversary nations. The statute is shot through with protections that I think are key to the concern about closing off the vulnerability of access to the data. So that's a sincere justification for Congress's desire here to act. We think it's a compelling interest and it's narrowly tailored. Then you get to the question of what to do about the fact that there's also this interest in covert content manipulation. And in the First Amendment context, this court in cases like Heffron has made clear that once you have a justification that satisfies the First Amendment, you don't need to go further and look at other justifications to decide whether they would independently satisfy First Amendment scrutiny. So I think it's not necessary for the court to go on and probe whether it thinks that covert content manipulation itself independently justifies the law.
Right, so they don't
now, my friends say
that's
all fine and good, but they think covert content manipulation is just per se illegitimate. And I honestly don't understand how that argument could carry the day. Because just imagine if Congress passed a law that said the PRC can't covertly manipulate TikTok. Obviously, that law is not going to violate any constitutional principle. It's a laudable goal, I think, for our legislature to protect us from foreign adversary interference like that. And so there's nothing that's inherently impermissible about wanting to guard against that risk. Maybe you could say that it sweeps in too much protected speech in the way it's operationalized in the act here, but there's certainly no fundamental taint or anything akin to racial discrimination to call into question whether Congress could seek to vindicate that as one of many interests. So I guess to just kind of bring it all together, what I would say to the court is they have basically acknowledged that data protection is a compelling interest. That was Congress's real interest. It provides a sufficient basis on its own to uphold this law. The court could say just that and affirm.
I don't know how we do that unless we accept your argument that the post-divestiture provision that stops them from conferring on the algorithm is not a speech impediment, meaning it's very hard for me to say that it's not to decide that question.
That was
that
me.
It is a
Hold
speech
on.
impediment, and one that.
So that was on me. The screen got yeeted. Apologies. I was trying to answer something in the chat. Let me pull this back up as we get to the end of these. We'll probably get into very shortly the rebuttals.
That on its face itself has to be analyzed separately from the data.
So, Justice Sotomayor, let me begin by saying, again, that we do think that an interest in preventing any operational agreement between the U.S. subsidiary and ByteDance, which is the relevant provision you're talking about, is justified by data protection alone. And that includes with respect to cooperation on a content recommendation algorithm, specifically because of the concern that it necessitates data flows between the companies. So I think that as a factual matter, that could justify Congress enacting. But to the extent that you think that actually the prohibition on coordinating with respect to an algorithm reflects some kind of impermissible content-based problem with the statute, The statute has a severability clause, and I certainly don't think that it would give the court a basis to invalidate this law or to stop it from operating with respect to all of the provisions that operate to protect data security.
Really,
and most of it suggests that that little piece of the law has to be on its own severed from the rest of how the statute operates.
How does that affect whether we would apply, because assuming it's data protection, then I would think that strict scrutiny wouldn't necessarily apply. I could understand applying intermediate scrutiny. But how do we do that with respect to this part, the algorithm issue? How do we get to intermediate scrutiny with respect to that?
The way you get to intermediate scrutiny there is to recognize that prohibiting foreign adversary control over the operations of the platform, including with respect to the fundamental backbone of the system, is not based on any protected speech or content based in the relevant sense.
So then you don't
I've been thinking of it as akin to something like a piece of software you might have on your phone that would allow the Chinese government to listen in on every American conversation. If Congress wanted to enact a law that patched up that vulnerability and said, you can't use that piece of software or you can't coordinate with Chinese companies with respect to it, clearly we would recognize that closing off that capability of China is a laudable and, in fact, compelling government interest. And I think when it comes to the risks that foreign adversary control pose here, it's similar in kind. It's simply trying to prevent access by the Chinese government to the TikTok system writ large, and that includes through the use of the algorithm.
Thank you.
Could the president say that we're not going to enforce this law?
I think as a general matter, of course, the president has enforcement discretion.
And would that then adequately protect, would that be binding? In other words, protect the regulated community so that they could rely on that under due process principles going forward?
That raises a tricky question. So I think there would be
then it's not going to be adequate.
I think there is a strong due process argument that the third-party service providers could invoke if there were enforcement action based on a period of time when the president said the law wouldn't be enforced. The kind of
They're not going to take
case,
that risk unless they have the assurance that a presidential statement of non-enforcement is, in fact, something that can be fully relied on because the risk is too severe otherwise, right?
I think that they might judge that based on this court's precedent in the due process space and principles of entrapment by estoppel, maybe they have a sufficient safeguard here to allow them to continue to operate. I would think even before a non-enforcement policy were announced.
We've gotten to entrapment by estoppel. We've gone so far down the nerdy rabbit hole that we have gotten to entrapment by estoppel, but we'll get there. We'll get there. The question is, what are the service providers to do on January 19th? What is the App Store supposed to do? What is the Play Store supposed to do? What is the server supposed to do? Like, what do we do on the 19th? Because you can't really rely on what an incoming administration will say on the 19th, not until the 20th. But remember, the Supreme Court's being asked for two things here. One, they're being asked to find that the law is not constitutional. And two, they're also being asked to issue an injunction to stop this from going into effect on the 19th, which is why we got the Solicitor General from the government side arguing this is a game of chicken. We need to let it go into effect to force the hand of the other side, because they say that this isn't really a choice and they can't divest at all. But when it goes into effect, maybe they actually can.
Of course, the president-elect would want to review all of the updated national security information that has come in over the last 4 years that undergird Congress's judgment here. But the final thing I would say is that even if you think the third-party providers are simply going to choose not to continue to provide these services because it's too much of a risk to take on, again, that's not anything permanent or irrevocable, and that might be just what the PRC and ByteDance need to start taking seriously some of the public reporting about interest in acquiring the company.
At one point, Mr. Francisco suggested that what we might want to do and what he would regard as certainly preferable to a decision affirming on the merits is to issue an injunction. Pending, I guess, consideration of what we now regard as the cert petition that was filed here. What do you think of that suggestion?
So I think this court doesn't have any basis to enter a temporary injunction unless it thinks petitioners are likely to succeed on the merits of the First Amendment claim. And to be honest, I think that there is no argument to be made that you should find that likely success. This is an act of Congress. This isn't some unilateral action by the executive branch, but it actually was action in parallel between the executive and Congress.
You can't do
where
that.
Congress took action to close up a loophole in some of our laws. The executive had tried to force divestiture of TikTok under the Trump administration, but that had gotten tied up in litigation about those authorities.
In the Ninth Circuit.
So Congress came in and provided additional authority based on a substantial record, including with respect to the data harm. And I don't see any basis for this court to displace the deadline that Congress set without finding that actually there is a potential First Amendment problem here.
Do you think we have
Which I don't
the
think they'll
authority
find.
to issue an administrative stay, as we have done in other cases, or do you think that the January 20 deadline prohibits us from doing that?
I don't think this court has a formal basis to not issue an administrative stay if it believed that that was necessary to assist in the court's own consideration of the case. And I would obviously defer to the court and whether it has a sufficient time to resolve the case, but we are here ready to submit the case today, and I think it is in the interest of Congress's work and our national security to resolve the case and allow the statute to take effect.
You need to let it take effect and then decide.
Can I just test to see whether your recollection of what Mr. Francisco said about a warning is consistent with mine? I did not hear him say, he can address this in rebuttal, that it would be acceptable to his client if Congress had said there has to be a stark warning on every TikTok, such as, warning, the communist China is using TikTok to manipulate your thinking and to gather potential blackmail material.
He didn't.
Did you hear him say that that would be okay?
I don't think he's made that concession, but even if he had, I don't think that would address the government's national.
He didn't say that. He said there could be a warning and that would be more narrowly tailored, but he didn't say that every TikTok, could you imagine scrolling TikTok and every 30 seconds, warning, mind control? Like we've gone all the way far afield, but that is what the court is here for, to take things to the, maybe not the logical conclusion, but the furthest out line that you can get to, which is, would a warning be sufficient? And she's saying not for the national security interest, which I imagine is going to go back to data collection.
National security concerns. And one of the points here is that it's not just data privacy. So even if you could somehow put users on notice that the PRC could obtain their data and they choose to disregard that, it's not a data privacy interest, it's a national security interest. There's a distinct sovereign harm to the United States if our foreign adversary can collect this massive data set about 170 million Americans. And as Justice Kavanaugh touched on, there are a lot of teenagers using TikTok today who might ignore a warning like that and not really care, but they're going to grow up and they might become members of our military. They might become senior government officials. And for the Chinese government to have this vast trove of incredibly sensitive data about them, I think obviously exposes our nation as a whole to a risk of espionage and blackmail.
Thank you.
And that, I think, is probably their stronger
I did want to touch briefly on the questions about
data.
history and tradition here, because my friends have said several times that the Communications Act of 1934, which we think is roughly analogous to the type of restriction that Congress was seeking to enact here, is justified entirely by concerns about scarcity, how you can't have sufficient bandwidth. And I, of course, recognize that scarcity is what created the need for a licensing regime in the first place. But I think it's important to clarify the historical record here, that in choosing to limit foreign control of radio stations, of broadcast stations, Congress specifically cited a concern about national security. That is written into the statute. National defense was one of the listed purposes of having that kind of restriction. And so I don't think my friends can succeed in being dismissive of that concern about history and tradition and what it shows about the national security judgments that undergird this law. The one other factual point I wanted to make, to be responsive to a few points that my friends have touched on, relates to whether TikTok US has the ability to alter this algorithm, whether divestiture is feasible, how ByteDance has manipulated the platform in the past. With respect to the algorithm, I think we're simply talking past each other. We don't dispute that TikTok US might engage in some functions in the United States to customize the algorithm for a US audience. The thing we're worried about is happening long before that over in China, where ByteDance is developing the source code, creating the basic backbone and functioning of the system, and is then blasting out the algorithm for use by the various subsidiaries in their home country. So we're not seeking to regulate any activity that TikTok US is engaged in here. Instead, what Congress is doing is trying to close off the vulnerability of PRC access abroad. With respect to the feasibility of divestiture, my friends have said it would have been impossible to do this within 270 days. You know, at the outset, obviously, there's no inherent impediment to divesting a social media company. We just saw Elon Musk buy X or Twitter in about 6 months from offer to completion. And even with respect to this particular company, I think my friends are not well positioned to complain about the timeline because they've been on notice since 2020 that unless they could satisfy the federal government's national security concerns, divestiture might be required. But in any event, I don't think that the court should fault Congress for trying to balance competing interests here in making sure that there was a period for compliance and trying to preserve access to the platform for Americans while taking steps to safeguard against the risk to national security. Finally, with respect to the question of whether ByteDance has taken action on the PRC's demands, there is evidence in the record that Congress consulted to demonstrate that outside of China, ByteDance has taken action to misappropriate data at the PRC's request. That included efforts to track dissidents in Hong Kong, protesters there, to track Uyghurs in China itself. We know that ByteDance has misappropriated U.S. data with respect to surveilling of U.S. journalists, and there was evidence in the record reinforcing the conclusion that ByteDance has been asked by the PRC to undertake efforts to censor content and manipulate the platform at the behest of the Chinese government. So I don't think there is a factual basis to dispute the record that Congress had before it. If the court has no further questions.
Tonks asked, is interrupting less good, bad, or neutral? It depends on what the court is thinking.
If I understood correctly...
Sometimes they ask less questions because they are just like, whatever, you're not changing my mind. Sometimes they ask less questions because they're already convinced. So it's neutral because we don't know which way they are thinking, but they have asked less questions.
After President-elect's first term, he passed an executive order requiring divestiture, correct?
That's right.
And this...
Travis asked a great question in the chat saying, wait, we've been saying this whole time TikTok is a US-based company. TikTok Inc. is the US-based company that is owned by foreign subsidiaries. So how can they be compelled to shut down? They're not being compelled to shut down. They are being compelled to divest the ownership of the company. So it is a nuance with a difference. But TikTok Inc. is the US-based company that is owned by a foreign subsidiary. So the foreign subsidiary is being required to divest out. TikTok's lawyers say, we can't do that. We can't divest out the foreign subsidiary. So TikTok is saying that's impossible. The government is saying, no, it's not. You just divest it. So they are owned by foreign subsidiaries.
That was challenged in court and state as a result of him exceeding his executive power to do that. But this bill followed a bipartisan investigation, correct?
Yes, that's right.
I am a little concerned that a suggestion that a president-elect or anyone else should not enforce the law when a law is in effect and has prohibited a certain action, that a company would choose to ignore enforcement on any assurance other than the change in that law. But putting that aside, on the 19th, if it doesn't shut down, there is a violation of law, correct?
Yes.
And whatever the new president does doesn't change that reality for these companies.
Correct.
That's right.
How long is the statute of limitations in effect, assuming that they violated it that day and later continue to violate it? But how long does the statute of limitations exist for a civil violation of this sort?
It would be a 5-year statute of limitations.
Thank you.
Thank you, counsel. A rebuttal?
And now to rebuttals.
Thank you,
Which
Mr.
will be
Chief Justice,
shorter.
for points, all of which go to why we think this law would fail, whether you applied intermediate scrutiny or strict scrutiny. I'd like to begin with the least restrictive alternative, simply prohibiting
That's a strict scrutiny
TikTok
prong.
Incorporated from disseminating any of the sensitive user data to anyone, including ByteDance, under the threat of massive penalties.
And they've
That is
said they've said they can't restrict TikTok Inc. US from disseminating data to ByteDance because ByteDance owns the algorithm, and so the algorithm won't work if you don't have information going back and forth. So this is the rebuttal from the attorney for TikTok, Fisher, I believe.
Definitely a less restrictive alternative. Now, my friend pointed to the NSA negotiations. Well, the sensitive user data that we're talking about and that were of concern in the NSA negotiations were not the type of technical data that she's talking about. The NSA did allow certain types of non-sensitive technical data to go back and forth, but that wasn't anybody's concern. And as we say in page 23 of our briefs, they simply cut off the negotiations without ever raising those concerns. But to be clear, if that's a concern, sweep that into the ban too. Put in that non-sensitive technical data into the ban too. We'll deal with that. It's a lot better than simply being forced to shut down. So that is most definitely a less restrictive alternative that would address data security. We talked about the under-inclusiveness and Temu and Shein, the two large e-commerce sites. Justice Kagan, you might have seen Temu during the Super Bowl. It was heavily advertised. It's one of the most popular e-commerce applications in the United States. It's got 70 million users. Justice Sotomayor, you were asking what they collect. This is from Joint Appendix 339 to 343, the U.S.-China Economic and Security Commission Review Report. Shein relies on tracking and analyzing user data, draws on customer data and search history with the assistance of artificial intelligence algorithms. It requests users share their data and activity from other apps, including social media. So they apparently go into your social media apps and suck up all of the information. Because they're e-commerce apps, they take names, addresses, and credit card information. If you look at the privacy policies on their website, they collect location data. It looks like they might even collect, at some level, GPS location data. So they collect massive amounts of data. Point 3. Their mere covertness argument makes no sense for the reasons that the court explored. If mere covertness were the issue, a disclosure would make perfect sense. Yet they're not concerned about mere covertness. They're concerned, as my friend suggested, with getting Americans to argue with each other. Well, you know.
Well, that's what the court suggested. They said that it's not the mere covertness, it's also data.
As far as I can tell, that's what news organizations do in this country every single day. That's what we call editorial content. That's what we call content itself. And so it's trained directly on the content. But even if you thought somehow that the mere covertness were the issue, that definitely could be addressed through a risk disclosure. So the data sharing ban, the risk disclosure, those are obvious less restrictive alternatives. And had the government considered them and rejected them, we would be in a different position.
Well,
but if you look at this record, those are two less restrictive alternatives that the government did not address at all. Whether you apply strict scrutiny or intermediate scrutiny, that is fatal because under both standards, restricting speech has to be the last resort, not the first one. And when you fail to consider less restrictive alternatives, you fail under either standard. My final substantive point is we absolutely think this court has the authority to enter an administrative stay. I didn't understand my friend to disagree with that. We think that given the enormity of this decision, given the complexity of this case, it would make perfect sense for this court to enter an administrative stay. I also think you could enter a preliminary injunction. Yes, likelihood of success is one standard, but you don't have to determine ultimate success. And as you do in other related contexts, like with respect to stays, you often make clear that you are not addressing the merits of the case. I think you could do that here. The bottom line, Your Honor, is this case ultimately boils down to speech. What we're talking about is
the government says it doesn't.
And my friends on the other side, when you cut through everything else, are ultimately worried that the ideas that appear on the TikTok platform could in the future somehow manipulate Americans, could somehow persuade them, could somehow get them to think something that they ought not be thinking. Well, that whole notion is at war with the First Amendment. If the First Amendment means anything, it means that the government cannot restrict speech in order to protect us from speech. That's precisely what this law does from beginning to end, whether you look at its text, whether you look at the government's justifications in its brief, where they talk about being worried about speech criticizing our leaders or undermining democracy. It's what you see in the House report, which drains specifically on the dangers of misinformation, disinformation, and propaganda. And it's what you see in this legislative record writ large, which is saturated with objections to TikTok existing content. We ask that you reverse the court below. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
And that is the end. All right. We have reached the end of oral arguments for the Supreme Court with that brief rebuttal. And we have gone through a full I think they ended up going a little more than 2 hours. It's always hard for me to tell because I pause as we chat, but a little more than I think 2 hours of the arguments regarding TikTok. Let's do a summary. Let's answer some questions. Summary first. Well, let's embiggen first. And then I'm going to go play in the snow. At the end of the hearing not really the hearing, at the end of oral arguments with the Supreme Court, we heard from the consolidated cases, the lawyers from TikTok, the lawyers representing TikTok creator, the lawyer representing TikTok creators, and the Solicitor General from the government. The Supreme Court is being asked to do two things with regard to TikTok. One, either do an administrative stay or an injunction to pause this law from going into effect on January 19th, the day before the inauguration of the next administration, or to rule on it outright. But really, they are focused on, we would like you to stay it first so it doesn't go into effect on the 19th. The court asked all of the attorneys, what happens if the law goes into effect? And the attorneys for both the creators and for TikTok indicated that essentially, if this goes into effect on the 19th, TikTok will go dark. That's not my understanding of how this law would actually play out. And the government has said part of the date of the 19th is a game of chicken here. TikTok keeps saying, yes, it will go dark. No, there's no way we can divest. No, we're not allowed to divest from the government of China. They have said no. TikTok US cannot divest from its ownership and from ByteDance and have the algorithm. That can't be exported, which means data from the US has to be exported to continue to inform and operate through the algorithm of TikTok. But my understanding is that the servers could be an issue because Oracle could choose not to host that information on their servers anymore as of the 19th, which would cause problems. Would it be a complete blackout? I don't know. And the App Store could no longer have TikTok on it. If you already have TikTok on a device, would you be able to open it up and go on TikTok? Yes. What would that experience be like? Unsure, because if Oracle stops hosting the servers, then you are going to have a big issue on the 19th, which may happen. It's a very real possibility. The court could also issue an injunction for a week or however long they would like to. So we'll see if the court issues an administrative stay or an injunction. The government is asking that the court let this law go into effect as it is and says that this law is constitutional. And that's the second part that the Supreme Court has to decide. Is this law constitutional as written? Part of the argument is over the level of scrutiny. What standard is the court going to apply to this law to determine if it is constitutional? The government argued this goes to intermediate scrutiny, which I described at the beginning. The TikTok et al. Plaintiffs said, no, this needs strict scrutiny, and if so, it doesn't meet it. What level of scrutiny the court applies matters quite a bit. The government argued, look, no matter what level of scrutiny you apply, this law is constitutional. TikTok and the creators said, whatever standard of review you apply, this law is not constitutional. So two parts. Will there be a stay? And will this law be determined to be constitutional or unconstitutional? Is this an issue of national security? Is this a government restriction on speech? And how will the court parse the two? We will have to wait and see. The court can take quite a long time with their written decisions. I hope we will see some decision on whether or not they will allow for an injunction or not. Hopefully they will say either yes or no to that part before the 19th, but TikTok is in limbo. And my suggestion is, if there are creators you love to support on TikTok, those creators' livelihoods are potentially going to be upended. Find them on other platforms, at least in the meantime, while the uncertainty is happening. So we will see how the court parses this. Very interesting to me is that the arguments from the platform seem to throw Section 230, which is part of the 1996 Communications Act that platforms rely on to operate. If Section 230 goes away, everything we do on the internet changes drastically. But platforms heavily rely on Section 230 to prevent them from being sued for what user-generated content says on their platform. TikTok leaned in and said, our algorithm is an editorial decision. It's the first time I've ever heard a social media company say that before the court. Most social media companies that come before the court, and there have been numerous in the last few years, come to the court and say, our algorithm is not an editor. Our algorithm does not make publication decisions. We are not a publisher as a platform. We are more like a host. We host the user-generated content. We do not editorialize. We do not act as a publisher. TikTok came into the Supreme Court today and said, our algorithm is the editor. That is the editorial genius that makes TikTok different. And getting rid of that genius and separating us from that algorithm, which is really the underlying heart here, not just somebody else needs to own the company, but then you also can't associate with that algorithm. That's really the core of the issue for TikTok, is we don't want to have to go get a different algorithm, and we don't want to operate with a different algorithm, is that our algorithm is making editorial decisions. And that to me is wild, like wild that is the argument. I know you have lots of questions. We've got lots of questions, but where we go from here, I am going to keep following. I'm very interested on how other social media platforms respond to this. Will TikTok's argument that their algorithm is in fact an editor impact other platforms? We will have to see. Is it going to come up? Yes. In the cases I cover, you've seen it. We cover a case in Florida, the Laundry Petito civil suit. They started talking about the Depp Heard case in court from Virginia. We've seen things that happened in South Carolina in the Murdaugh case, referenced back in the Karen Reed case in Massachusetts. So does what TikTok argues here come up in other arguments? Yes. And have there been numerous lawsuits over whether or not you can sue YouTube, for example, in a case that I covered? Can you sue YouTube for the videos that they show, for the decisions that the algorithm makes, and for the outcome of that? And the court has denied those in the past. But now you have a different social media platform saying, no, actually, we do editorialize. Our algorithm is, in fact, a publisher editor. And does that stop TikTok from coming forward in court and saying, no, we have Section 230 protection? Did TikTok undermine its own Section 230 protection? And will we see others coming forward and suing TikTok? In the TikTok psychic lawsuit, do you see the professor in Idaho now coming forward and saying, oh, TikTok, you're saying that you're the editor? Fine. The TikTok psychic doesn't have any money, but you sure the fuck do. So we're going to now sue you too, because you went into court and argued that your algorithm is in fact an editor making editorial decisions. So let's sue you. So is this going to change the way other litigations move forward? Are we going to see other lawsuits against TikTok open up and saying, hey, TikTok, your lawyers went in and argued in front of the Supreme Court that your algorithm is an editor. So you are stopped from coming into court and making a contrary argument and saying that you're not. Did they just throw open the door on lawsuits for TikTok? And could that ultimately change TikTok? I don't know how YouTube operates if YouTube is open to suit for everything everyone ever publishes on the platform. I don't know how any user-generated form would operate in that environment. And in the lawsuits that I covered regarding, at the time it was Twitter and Google, or Twitter and YouTube specifically, arguing that they could not operate in that environment, did TikTok just create that environment for themselves, arguing that they are in fact a publisher and therefore not subject to 230 protection? A lot happened today in court, and I'm very interested to see not just what happens on the 19th, but what the fallout is from them seemingly throwing open the door to their own Section 230 protection. I'm very curious to see where we go from here. All right, let's get to some questions, shall we? You've got them, I've got them, we've got them, lots of them. Will I get to all of them? Probably not. Did I stream for an ungodly amount of hours this week? Yes. Yes, I did. That's not what I meant to do. I meant to do this. It's very interesting to see if, in trying to save itself, TikTok really harms themselves with that 230 argument. Just wild. Deanna, what do I think they'll decide? I don't know. I don't know what they're going to do. And I don't follow the current Supreme Court closely enough to have a crystal ball on what they will do. I'm very interested to see what standard they pick. Even if they pick strict scrutiny, everybody conceded that the data is a compelling government interest. So if they pick strict scrutiny, they will find a compelling government interest. It's whether or not it's narrowly tailored. Do I think they can find it? I think they could. It's really going to depend on what they want to do with this record. The thing I'm most interested in first is, will they grant an administrative stay? And I don't know if they will do that. I don't know if they will just let the course play out. So, but again, I don't follow the court closely enough to be able to say this justice does this. In law school, I was doing enough, especially with Supreme Court law, that I would be like, oh, this judge is probably going to do this. This judge is going to do that. Can I do that with this group of judges? Not a chance. Not a chance. I don't follow it closely enough because I really like the trial level court. I find this topic fascinating, but I love trial level court because that's where you get all the stories. I love that. And we will see more of that and coverage of trial level court on Monday when the new Quick Bits comes out. So I should remind everybody, especially those of you that are new here, that the Law Nerd app does not share your data first, does not ask you to share your contacts second, and keeps you in the loop with when I'm live and dropping content, including when I try to summarize the 7-hour stream that I did on Wednesday in Quick Bits. So if you are not a Quick Bits subscriber yet, if you do not subscribe to The Emily Show on your podcast platforms, I would do it just to see if I can actually summarize all 7 hours of what I covered into Quick Bits. I haven't recorded that yet. Let's see if we can. Let's see if we can. I don't know if I can, but let's see if we can. Let's see. Avalon said not a TikTok user, but interested to see how this will legally impact other companies and platforms. Me too. The ownership of the company is specific here. I also will say, of the content creators I know that create on TikTok, a large amount of creators choose to keep the TikTok app on a completely clean phone, meaning they have no other information on that phone. It is a phone that does not have their contacts. It is a phone not connected to their phone number. It is a phone that they don't always access through their home Wi-Fi, that they will access through a different SIM card. A lot of creators have TikTok on a completely clean device, which I also find to be very interesting. I do not keep TikTok on a device with any of my other information. Most state governments, including, and then the federal government, have banned TikTok from any work-related devices. But most people I know in security do not allow TikTok to connect to their home Wi-Fi and will use a separate SIM card for it. So people do take pretty strict measures to keep TikTok separate from all of their other data, because there is quite a lot of information about TikTok gathering keystroke data, even when you're not on the app. So it will be interesting to see. Psychedelic manic incarnations, apologies, says, what if you don't have an account? I don't know if TikTok will let you watch TikTok if you don't have an account, but there have been numerous lawsuits showing how much data is tracked. This was the last one I covered was a California lawsuit, that even if you don't have a logged in account, that TikTok still takes that data off of your phone. Have they patched that? Have they changed that? I don't know. So Edgy Espresso says, I never knew this was a thing. That's why I'm sharing with you. These are conversations I have with others who create, and realize that maybe not everyone is having these conversations. So hopefully that conversation is helpful. So let's see. Creators might be aware of the security, but normal users may not. Is that part of the problem? The government would argue that's part of the problem. I think it is something that is not discussed widely. And when you are in the realm of creating, you are more focused on it. But the government argued to the Supreme Court, look, even putting a warning on it is not going to be enough. But also, I would like to see transparency forced with all of the companies. I would like to see more transparency on exactly what's collected and what's used. We're getting towards that direction, but we're not there yet. I would like to see more transparency either way. Silly Munchkins for Life said, now I need a separate Wi-Fi for TikTok or a VPN for TikTok. For those of you that have asked, and many of you did, will a VPN work after the 19th for the TikTok ban? My answer is, I don't know how that will work. And I don't know what it looks like to try to change where your app store is located, because part of the issue is going to be the app store. So if you're just using a VPN to place you in another country, I don't know how that will interact with the app store. I don't know how that works well enough to tell you one way or the other. Because the app store is going to be the issue, and you not being able to update the app on your phone is going to be the issue. But then if you try to move your phone's location, to move your entire app store location to another country, how does that impact your other apps? I have no idea. So I'm not going to tell you one way or the other. I don't know how that will work. I do know that I've tried to log into other web stores for like Nintendo to try to download games that weren't available. And it is a wild process, and it is not easily done. So I think using a VPN alone to say, hey, I'm logging in from another country is not going to get you there, because trying to show that you're in a different country for your app store is going to be very different. So I think that's going to be, a problem, but we'll see. We'll see. Meow though 9 said Suica was worth it though. It totally was. It was a whole fucking process, but it was worth it. And then they put it on the US App Store or the US Nintendo Store, which made it easier. So yes, I have tried to switch my Nintendo Store, but that is a whole different thing. So let's see. Let's see. You just heard all this and you want to use a VPN to continue to connect to it. No, I don't, but some might. We've gotten lots of questions about it, but I also think this is the place to ask questions. And one of the questions is, but what if this, but what if this, but what if then? Does the VPN matter when they take info from you using your phone? People are asking about using a VPN so that they can still access the app. Does a VPN block them keystroke logging if they are still keystroke logging? Probably not, but I don't know enough. I am not a data or cybersecurity expert. So do I use VPNs? Yes. Do I use them to try to switch where I'm located? No. So do I have all that information? No. Are there cybersecurity experts on this platform and others that are much more qualified than I am? Yes. I'm very good at asking the questions. I cannot answer all of those questions for you because I do not know. I am not a cybersecurity expert. What I can tell you is when a large portion of people who know more than I do refuse to put this app on a phone that has any of their other information on it, it gives me pause. So it gives me pause. Quite a lot of pause, actually. So let's see. Oh, this is so exciting. Laura said, I'm meeting with an artist this week for planning of my Throne of Glass tattoo. Also sent you a message on IG for a gavel that makes a dun-dun sound from Law & Order. I need to see if that sound is protected. It's probably actually copyrighted, but fantastic. And thank you. Because if I was Law & Order, I would copyright it. Snow day in TM with the law nerds. I know. I want to go walk around in the snow. Since the moment I got out of bed this morning, the snow has been falling and I love it. Love it. Mandy said, loving live Emily 3 times a week. Me too. Me too. Me too. So if you guys aren't subscribed, I will just tell you one more time and the mods will put it in the chat. But if you're not subscribed to my Quick Bits channel and want to stay in the loop with things that I cover in a more quick fashion, on Mondays, go support the podcast over there. It's a huge content shift for us, but a really good one. But supporting that channel over there absolutely helps. So thank you. I appreciate it because we are user supported over here. Let's see. Kudara said, I have court reporting homework to do, but this was way more interesting. Can you court report this? Could you go transcribe us? It might help. Way more interesting than Q&A about a traffic accident. That's fair enough. Traffic accidents are fairly run of the mill when you get to it. Let's see. Mary said, watched EDB all through my pregnancy and now baby is watching with me on his first snow day. Oh, have a cuddly, amazing snow day. Heather asked about my brother. Is he doing okay? Yes. Brother is in California. Work has been busy as one can imagine. He works for the fire department, but on the beaches. So yes, just busy. Family is still safe from the fire zones in California, though the air quality, smoke, devastation, friends that have lost houses, all of that is emotionally difficult. All of my family are physically safe. The ash and the air quality is concerning to me, especially with regard to my parents, but there is only so much you can do. And it is the worst fires I have ever seen in California. And I lived there for 45 years of my life. So let's see. The TikTok lawyers, I don't think a good attorney. I don't know. He was questioned strongly. I don't think they didn't understand him. I think he was questioned strongly. So there were a lot of questions for him. The attorney for the creators made some really excellent analogies and point. I think the attorney for the creators made analogies that were easier to follow than Jeff Bezos's kids being kidnapped. So I think that was helpful. So let's see. Anthony said, question, why is TikTok being sued versus other social media like X, YouTube, Instagram, Facebook? I'm confused. Anthony, TikTok is not being sued. Congress passed a law about who can own a social media app like TikTok, and I'll link the law down below. Miguelina, I think I have it in the prep document, but I will link the law down below if you guys want to go read the act, the PIFT Act. So Congress passed a law regarding specifically foreign ownership, and the other companies do not have foreign ownership. So that is why TikTok specifically is targeted here. Michael Toast, good to see you in the chat. Good morning. Well, good afternoon now. Let's see. Charlene asked, is arguing before the Supreme Court the pinnacle of an attorney's career? It depends on the attorney. Some attorneys want to be judges. Some attorneys want to win big cases. Some attorneys want to do plaintiff's work and win multi-million or billion-dollar judgments. Some attorneys want to argue appellate work. So for appellate attorneys, it is a big deal and a big honor. For trial attorneys, like the litigation dogs, want to win those big verdicts. So it really depends. Like for criminal defense attorneys, an acquittal of clients might be a much bigger deal for them than ever arguing before the Supreme Court. So it just depends. For appellate lawyers, it's a big deal. I never wanted to be an appellate attorney, so no, all of that would make me crazy. I like the litigation work, and that is what I do. So that is it. Let's see. Alexa said, why would the lawyer admit to the algorithm being speech? Because they have to argue that the company has a free speech right to get into strict scrutiny. If there is not a fundamental right, then it goes to the lower scrutiny. And if it goes to the lower scrutiny, intermediate scrutiny, I don't know why I can't say those two words together, but I can't. If it goes down to intermediate, then it's more likely that the law is found constitutional. So they were in the realm of, we want that strict scrutiny, and that's what they were going for. But it's wild to me. Just wild to me. Celeste said, why do they keep talking over each other? Because the lawyers are not reading the faces of the judges when the judges want to ask a question. And when the judges are like, I want to ask a question, they're going to just cut you off and ask the question because their questions are what matters. So the court's going to cut off the attorneys more than the other way. Though when the court says thank you and the lawyers don't stop speaking, it's because they weren't finished making their point. And sometimes you got to let the horse run all the way out of the barn, which I am totally empathetic with. You got to finish the sentence before you get to the next one. Miriam asked, didn't the Supremes already rule on this? They're not going to contradict themselves. They did not already rule on this. The DC court ruled on this, and this is the DC Circuit Court found that the law was constitutional. They are taking this to the Supreme Court, asking the Supreme Court to find that the Circuit Court was wrong. They're asking the Circuit Court to be overturned. Let's see. Slayer Nightshade said, I worked for a company that hosted user-generated content, and they had me build a UI that held the content before going live so they could, quote unquote, monitor it. Now I'm thinking that was to get around Section 230. It might have been to say, hey, it might have been. It might have been. Malleus Maximus, good to see you in the chat, said, hey, Emily joining late. That's okay. Ignore if this is out of context or answered. No, we're not. We'll just get to it later. You said the federal court can choose not to broadcast. The federal court does choose not to broadcast. Federal courts choose not to broadcast. Is there more onus on lower courts to be public? And if so, why? I think lower courts balance the right of the public more. It's interesting because I did a interview with Lawyer You Know for his podcast, and we were talking about the differences in state court and federal court. And one of the things that he brought up, and I was like, oh, you make such a good point, is that federal judges are appointed for life. So like football is life. They don't give a fuck. They're appointed for life. State courts are not appointed for life. And a lot of state courts, the judges are elected. So the state court judges balancing the interest of their community is different than the federal court judges balancing the interest of the community. The federal court judges are like, oh, you mad, bro? What are you going to do about it? Because what are you going to do about it? You're not going to get rid of them. You can't vote on them. You don't know who they are when they get appointed most of the time. So what are you going to do? But if a judge refuses to allow access to a high profile case and then comes up for re-election, what are you going to do, bro? I'm going to run against you. There was a DA I worked with who really got sideways at a judge that I had worked with. That judge made me sideways sometimes too. I get it. And got sideways with this judge to the point of, oh, you like your job? Fuck you. I'm going to run against you. Ran against that judge and won. And won. Was like, oh, okay, this is what you're going to do to me? I'm going to take your job. How about that? I will take your fucking job. And she ran against him and won and took his job. So when you're looking at states where judges are elected, if judges make it difficult for the community to access the courts, the community will be like, get out of here, out of here. Or the attorneys will. And the attorneys will say, this is the reason I'm running against this judge. In California, it is very uncommon to run against a seated judge. It is not socially polite. It is rare that it's done. But if judges cross somebody, they will run against you and make you fight for your job or yeet you from your job. I Love Pie, it totally was a baller move. It was like, oh yeah? Come at me. It was a catch me outside moment. Was it Judge Abby? No, that was not Judge Abby. Judge Abby ran for an open seat. That was not Judge Abby. Judge Abby ran for a seat that was vacant against other people who wanted that seat, not against a sitting judge. Running against a sitting judge is a whole different political mess. But when you're looking at judges being elected, there is an interest there to work with their community and their local community more, which, to answer the question, yes, I think there is more onus on local courts to make the court more accessible and to make the community feel like they are involved in their court system at the local level. Federal judges do not give a fuck. And that's it. The federal court system said, we are not available for this. And they are not. So, I didn't even think about Judge Abby. That would have been funnier. It is definitely not Judge Abby's style. So, all of you are asking how Judge Abby is with the fires. Again, it makes work crazy. Lots of ash, lots of air quality, but physically safe. Josh H said, I don't see this going well for TikTok. There were a lot of difficult questions, weren't there? I'm interested to see if they find this to be a speech right or not. Finland mentioned all of the Finns woke up at the Finland mentioned. All of you are just like, hey-o, what's up? Yes. Michael Toe said, are each content creators having separate lawyers? No, it was a group of them that sued as group plaintiffs, more like a class action situation. Chibi said, my Starbucks app collects more data than my TikTok. I'm curious about that. Richard said, I suspect wiping the data is not considered because one, the ownership path isn't trusted. That's fair enough. And that ship has already sailed. That's also fair enough. What does it mean that ByteDance has to divest? Alleycat, it means that they cannot have, the US based company cannot have ownership that is a foreign entity and cannot send information back and forth to ByteDance. So that is the broad strokes of it. Overnewben was saying ByteDance will do anything for TikTok, but it won't do that. I will do anything for love, but I won't do that. They're like, no, we won't. And that's why the government was saying this is a game of chicken. The government's like, they say they can't, they say they won't, they say they're not allowed to. But we don't know until we see. Brandy Rose said, off topic, is Judge Wyndham from the Jinx the Judge Wyndham? Yes. Judge Wyndham from the Jinx is one of my favorite judges that I ever appeared in front of. He seems like a joy to work with. He absolutely is a joy to work with. I adore Judge Wyndham. He also had the chime in his court, like the yoga chime, like just a little like yoga chime to bring everybody to order. No banging gavels. I adore Judge Wyndham. It was fun to see him in the Jinx. I was surprised he was interviewed. It was a delight. So it was lovely. Kelsey said, hey, EDB, in the hospital waiting on surgery, please send prayers, happy thoughts, good vibes my way for me and baby. Sending all of the vibes your way, Kelsey. Please keep us in the loop. Be well. And I know that the Law Nerds are sending you all of the good vibes, the prayers, and all of the strength for a good and speedy recovery. Murfin said, my husband works in IT. I deleted TikTok after he told me all of the security risk. He reminded me there's a reason why our own government doesn't use it. Analytical Blarney said, we're not going to take it. No, we ain't going to take it, said both sides. Yes, they did. Both sides were like, no, we're not. So let's see. Sorry about the question. Don't apologize for questions, Anita. We're here. We've got questions. We're Law Nerds. Sorry about the question, but can you explain what is an algorithm for TikTok? Absolutely, Anita. Do not apologize for the question. The algorithm is, and I am not a technological person. Somebody can probably explain this better, but it is the coding behind how things get selected. So it is the coding of a platform so that when you see this video, what's the next video? And when you see that video, what's the next video? And if you log on to the platform, what's the first video you see? And how much data they gather to decide what video you should see. All of the social media platforms have algorithms. Algorithms take information back and forth on user data. How long you watch something, how soon after you click onto a video you click off, what thumbnails you click onto more, what kind of videos you watch longer or watch twice or don't watch. When it comes to apps like Instagram, it is, did a bunch of people you're friends with like this video too? So we're going to show it to them because we know who your friends are. And so we know if all of your friends watch this video, then we'll watch it. Or Emily, we see that you commented on this video. Get in the car, Elizabeth. So we're going to show that video to your son because you commented on it and he and you are on the same socials and in the same house and use the same Wi-Fi. So if you liked that video, we should probably just serve it to everyone else that is in your space. This is why when you look at a video on like Instagram, for example, you'll look at a video you like and be like, oh my God, I should send this to so-and-so. And then you look and they've already liked it because it shows you who already liked it. Right. They know they liked it. They know you two like the same types of videos, so they're going to show it to you next. That is the algorithm. It is that coding that gives and takes all of that information to try to keep you on the platform as long as possible. So I hope that was a good explanation. I'll have to ask Todd to explain it better. The algorithm shaded me, Lyndon. The algorithm shaded me. And my son sent me that video and it said, Mom, ? And I was like, I can't comment on anything. I need a sock account, which I do not have. Like, I need a Finsta that's not connected in any way to anything so that that's not getting served. But I see so many videos and I'm like, oh my God, I should send this to Judge Abby. Judge Abby's already liked it. So I'm getting that video because she's already liked it. My kid will come to show me a video and I'll be like, oh, I've already seen that. They know. They know. They know. Is the algorithm going to send all of us cat videos now? Yes. Is Amazon going to suggest to you, hey, you should buy this because of something you've been talking about? Probably. Is that the question here today? No. The question is about who owns TikTok and who owns TikTok, and not only who owns TikTok, but what information is being sent to a company that is beholden, the government says, to a foreign government. So that I definitely need a Finsta because I do. LK, right? I should, or all of my son is going to start getting sent is like Throne of Glass videos, which, by the way, I need to change my algorithm because now every time I log on to Instagram, I'm traumatized. So I need to just change it because I'm like, what? I can't. Chapter 89. So anyway, but have I been deep down the rabbit hole of dragons lately? Yes. Why? Because I don't know if I'm going to stream on January 21st. I don't know. It's going to be a short stream because I'm ready. I'm ready for Onyx Storm. Like, I'm just ready. Back to book conversations. Don't worry. Members will have a whole book we'll have a whole book day. Do not worry. So with that, let's see if I have any other questions. Ari asked if they said the fate of CapCut owned by ByteDance. They haven't said the fate of CapCut owned by ByteDance that I've seen. I haven't seen it brought up. So I don't know if the editing software will go away too. I don't know if CapCut is on the same servers. So I haven't seen what they're going to do with that. Megan, what did my son see? It was just a video of a get in the car, Elizabeth, but with a very robust voice. So it was not, the video itself just had implications, but my kid decided to shade me with it because he's 16 and he's like, what does get in the car, Elizabeth mean? And I'm like, we're not going to talk about it. We're not going to talk about it. For those of you asking about CapCut, CapCut's an editing app that is also owned by ByteDance. So what does CapCut have to do with it? They're also owned by ByteDance, but I don't know what will happen with CapCut. I haven't seen it mentioned in any of this, but we will see. ByteDance could also be petty and be like, we're taking it all. We're going to take all of our apps and go home. I don't know. J. Michael said section 230, right? Right? Leonard Soph said, I prefer TikTok for my small business promotions. It gets so much more traffic than anywhere else. Exactly. And that's what the creators said in their briefs, is that you can't just tell creators, go post it on Instagram. Creators are saying, I try to post it on Instagram. You don't get the same reach. It's not the same. Creators on Instagram are like, look, I have XYZ number of subscribers, and like 3% of those subscribers or followers actually see my content. It's just shared differently. Creators on TikTok say a higher percentage of the people who follow me see my content. And not only do a higher percentage of people who follow me see it, but a higher percentage of people who don't follow me see it, which is different than YouTube, where sometimes you'll be subscribed to someone and not see a video of theirs for months and months and months. Sometimes you'll see every single video they put out. It just depends. So it really, really depends on the particular algorithm of the particular platform. Should I ask Todd? Should I just ask Todd if we can have him have a algorithm conversation with us and explain what algorithms are, maybe we would ask. Maybe I should just ask Todd if we can have an algorithm chat on my channel. I'll ask and see so we can explain it better. So with that, Law Nerds, it has been 4 hours and almost 45 minutes. I'll ask and see what we can do. But if you are interested, Todd Beaupre, who runs Discovery at YouTube, has a number of videos on the YouTube creators channel if you want to hear him talk about the YouTube algorithm. But I'll ask and see what we can set up and talk about just what is an algorithm, how do those things work, what are the considerations, because these things go much deeper than my own understanding. There are, the YouTube creators channel has a lot of those conversations. If you follow Renee Ritchie, the YouTube creator liaison on YouTube, he has a lot of conversations with Todd. Todd's given interviews elsewhere on the platform, so we can ask. All right, Law Nerds, it has gotten very late, and we have got to go. James said I did a pretty good job explaining the algorithm. Thank you, James. Gold star for me. I tried. You guys, I will link some of the videos. I'll go look at the ones I'm thinking of that I can't name off the top of my head, and I'll link them down below. I want to go walk around in the snow because then I can come home and be hoogly. So I want to go snow, and then I want to have some Spike Talk chocolate and like log off of the internet for the day. For all of you who mentioned that there are other things going on in the world of law today, I saw that you mentioned Monday, there will be a new, Emily Show podcast on the Quick Bits channel. Monday, we will talk about it. Tuesday, we will be back here streaming. I don't think we have court anywhere on Tuesday. So Tuesday, we will be back here streaming all of the new. I'm not convinced that we're not at a point where we're not going to get more lawsuits in the Blake Lively stuff before next week. So it's going to be a busy week next week. Goldie, there's not going to be a BTS this week because I have streamed so much this week. My timing is skewed. I was supposed to do we were supposed to do 2 court days that were going to be long and then a shorter stream. And what we did was 2 court days and then the longest stream. Y'all warned me. I just overestimated how quickly I could talk. To Emily, time is a construct. Exactly. But that's also quite a lot for Team Baker. So to the moderators, thank you. The first week back, it's just like, we took some time off and now we're just going to stream for 75 hours in a week. So much. Law Nerds, it's so good to see you. I'm glad we got to do some appellate court together. I know it's a totally different process and it's fascinating. I hope you found it fascinating. I hope the explanation helped. All of you that just did your self-study, there you go. We've talked about the levels of Supreme Court scrutiny. I feel like I'm back being a TA in con law class and regretting my decision of selling my books from law school. Maybe we'll have to go, no, I know what books I want to put in my bookshelf, and they're not the ones from law school, but I think I might need them. We'll see. Law Nerds, you are the best. Have a wonderful weekend. Stay tuned to the Law Nerd app. Members, I owe you a post today with a bunch of documents. Don't worry, that will be up later. I got distracted yesterday. My apologies on that. It was, I didn't have salt. And in Nashville, you have to fight for your life for eggs and bread before a snowstorm. And I really decided I wanted to do some baking this weekend. So I'm like, I could probably use some more eggs. So yesterday I was fighting for groceries and salt for my driveway and my steps because Dr. B had a very long work day. And I was like, shit. Emily, did you know this storm was coming for like a week? Yes. Did you wait till the day before to go out and try to find ice melt? I mean, also, yes. It is. Somehow it's a French toast emergency every single time. Bread, eggs, milk. Always gone. Always gone. So with that, there was plenty of bacon. I'm like, what's wrong with y'all? How do we have no bread, eggs, and milk and plenty of bacon? Well, thank God for me, because I was able to buy extra bacon. So with all of it, take care of yourselves. Enjoy your weekend. Stay safe with the weather wherever you are. You are the best, Law Nerds. It is so good to see you. It's nice to be back for 2025. I will see you in the app this weekend, and I will see you next week. Streaming here Tuesday, Wednesday, Thursday. Bye, guys. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.